ಏನು ಹೇಳಿದ್ಯಾ ಸಾಹೇಬ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಸಾಹೇಬ್ರಿಗೆ ನಾನು ಬೇರೆ ಪಕ್ಕ
ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಇದೆ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ
ಆಯ್ತು. ಪರವಾಗಿಲ್ಲ.
Can you?
My lord, yesterday moved it, it has not been posted today.
ನೋಡ್ರಿ ಅದು
Which matter, my lord?
tomorrow. Tomorrow.
Lord, 2:30, question, madam. 2:30, madam. There is an urgency.
Tomorrow. Yes. EP, admissions preliminary hearing next day. SC/ST.
CP recalling. Friday in the, I'm going for under surgery.
Yes. Tomorrow. Yes.
Lordship, interim order pass ಆಗಿತ್ತು.
Hmm.
ಇದು amendment, you directed us to change the amendment. We filed the amendment application. Can we have it this week?
Yes, next week.
Your Honor, I have moved a matter, CP 1112 of 2024. It's a matrimonial transfer petition matter. Orders girodu. Your Honor, it can be had Monday, latest.
Where is that memo?
File.
Okay.
My lord, one CP transfer matter, please, my lord. League is in the filing counter. I require for Friday, my lord. I'll affix the FR number and he is in the filing counter. Why? Because matter is listed on Monday.
No, you move it tomorrow after getting that number. We'll have it on Friday. Why do you giving that? Yes.
Why?
For page wise adjournment, list number 1, page number 1, serial number 192. Page number 2, serial number 3 to 13. Page number 3, serial number 14 to 20. Page number 4, serial number 21 to 24. Page number 6, serial number 25 and 26.
26, my lord. Appearing for response number 8 and 9. Is a statement of objection about petition. Kindly have it and after vacation. my lord.
You are appearing for?
R8 and R9.
Yes. Who is other side?
Sampatanam
Have you
Shetty.
informed other side?
What is?
Yes, at the request of respondent. Is this matter next week?
Page number 7, serial number 27 to 31.
Serial number 29 ಅಲ್ಲಿ
29.
29.
Hmm.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಹಾಕಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಸರ್ವ್ ಆಗಿದೆ.
You will take notice. You serve a copy to him.
Yes.
Yes, Janardhan Reddy is directed to take notice. Yes.
R2.
R2. Yes. Our process ಅವ್ರಿಗೆ 1 week. Yes.
Say page number 8, serial number 32 to 35. Page number 9, serial number 36 to 39. Page number 10, serial number 40 to 44.
Minute 40, minute,
Yes.
I appear for the appellant. I have some melodies away the time. My wife is not taking well.
At the request of appellant, leave this matter after 2 weeks.
Okay.
Page number 11, serial number 45 to 48. Page number 12, serial number 49 to 52. Page number 13, serial number 53 to 56.
Serial number 54, my lord. I am for the petitioner.
Hmm.
I pressed 2 weeks time, my lord. He is not feeling well.
54.
Please, my lord.
You are appearing for?
Petitioner, my lord.
At the request of counsel for the petitioner, leave this matter after 2 weeks.
Much obliged.
Page number 14, serial number 57 to 60.
58, my lord, take up after vacation, ma'am.
58. At the request of counsel for the respondent number 2, leave this matter after vacation.
List
After
number
2
1
weeks ಅಂತ ಆಗ್ತದೆ.
for preliminary hearing, serial number 1, Vinita PC for petitioner.
APF petitioner.
Hmm.
Lordship, my prayer is only to limited prayer, your lordship seeking a mandamus, wherein a matter is remanded. The first deputy commissioner had remanded the matter. In fact, the restoration application filed by the claiming to be the legal heir of the grantee has been rejected by the Assistant Commissioner, against which they have filed an application before the Deputy Commissioner. The Deputy Commissioner, though the grantee has not produced any document, he has remanded the matter. But while remanding, your lordship, that is, he has not given any date for appearance or has not specified. I have purchased the property in 2010 and I have developed. And because of this restoration order,
ಜಮೀನು ಪ್ರಕರಣ ಉಭಯಂತರಿಗೂ ನೋಟಿಸ್ ನೀಡಿ ಸಂಬಂಧಪಟ್ಟ ತಹಸೀಲ್ದಾರ್ ಅವರಿಂದ ವಿವಾದಿತ ಜಮೀನುಗಳ ಮೂಲ ದಾಖಲೆಯನ್ನು ಪಡೆದು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ when this order has been passed
this
on
order was
28/6,
passed 28/6/24.
there is a direction to give a notice to all and pass an order.
Pray at your lordship that direction may be issued because I have purchased in 2010.
Now you take notice
I take the note.
and verify by the Assistant Commissioner what is the stage, whether he has received or he has issuing the notice, date has been fixed or not.
Yes, ma'am.
Government advocate is directed to take notice to respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies. Issue emergent notice to 1 to 6, 3 to 6.
Please.
He
Great.
served 2 sets copies.
Great.
Admission matter, serial number 2, Revati Adinath Narde for petitioner, connected matter, Madhukar Deshpande.
Your lordship asked me to produce the memo and the petition regarding the withdrawal. I'm just passing on all the certified copies, ma'am.
Yes.
Sir.
Okay, okay. Right. Okay.
All are ready?
Yes, ma'am.
Password. Password.
Serial number 3, Subramanya HB for
Petitioner in
petitioner,
this case, my lord.
Danappa Gurappa.
Avoid, report ಬರ್ಬೇಕು sir. Report ಬರ್ಬೇಕು sir.
The report is ready. Anyhow, the pen drive, one pen drive they have been.
You have,
CCTV footage came in.
Hmm.
But CCTV footage is there in the pen drive.
Hmm.
That is available for the 15 days. But however, there is only one pen drive is available here. Already 40.
pen drive,
Have to put together. CCTV.
report idya?
Report only they can't, my lordship, because they are asking the presence of the petitioner.
No, have they seen that police has to see that CCTV footage and given a report?
15 days, whatever has for this from this court, they have given for the 15 days, but they don't know what is there in the pen drive.
No, they should have seen that and let them give a report. Yes, these persons are present, then it will be useful for them.
Difficult to verify then, my lordship, who is this petitioner is deciding.
We
in
can't
this-
display and see it.
That Manya apartment, Haurela Prakara, the respondent is saying there and that.
Respondent idara ಅನ್ನೋದಕ್ಕೆ
So, police might feel difficult to.
no, that
They
you
assist to the police, it is much better.
you have the photographs of that the respondent.
Fine.
You give the photographs, then you can identify whether this person can be seen in this thing and all. Yes, you give that one photograph,
Please, ma'am.
that is easy. Or you can take the assistance of that party and verify. Please, you given a report instead of that way. This is not such a case that you have to see that and in the pen drive and all. Yes.
My lord, ಮತ್ತೆ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸ್ಟೂಡೆಂಟ್ ಅಲ್ಲಿ ಓದ್ತಾ ಇದ್ರೆ ಎಕ್ಸಾಮ್ ಬರೀತಾರೆ ರಿಪೋರ್ಟ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
Otherwise, the other direction, my lordship, for the both petitioner respondent can go to the concerned police station. They can see the video clip there, and if they find that is the respondent is there, adu ಮಾಡ್ಬೋದು. The direction might also be given to give the photocopy and the report by the return submission. If the presence should be of both the parties.
No, because we ask them to give that this thing.
Based on.
Pen drive, because it is all that it is a personal use of that this thing. We cannot do. Only police can see whether that who is that petitioner or respondent is residing there. Respondent residing. That is their allegation that you are residing here only. Yes, you can see and identify whether she is there, or you produce the photos. Police can see whether this lady is there, is working in that, presently she is in residing or not. Yes, you give that one photocopy, photos.
See, because the other photocopies, footage of that, the respondent, he has to give that. And whether they can identify the respondent this.
Footage ಅಲ್ಲಿ ತುಂಬಾ ಜನ ಕಾಣಿಸ್ತಾರೆ. ಅವ್ರು ನೀವ್ ಯಾರು ಅನ್ನೋದು ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ.
But that is not, they are not saying like that.
Hmm.
They are not saying like that actually. It is not clear and all.
No, they are not saying that it is not clear. See, they took that pen drive.
The issue is they're making, that's a house property is purchased by the respondent. And she's not regularly staying there. Whenever she comes to Bangalore, she will be there.
See, 15 days ಅಲ್ಲಿ ನೀವು ಎಷ್ಟು ಸರಿ ಓಡಾಡಿದ್ರೆ ನೀವು ಅಲ್ಲೇ ವಾಸವಾಗಿದ್ರೆ at least every day you have to pass.
Yes, my lord.
That will identify. Police.
Yes, please, my lord.
Yes.
Interim order,
Leaves this matter after 2 weeks.
interim order election, my lord.
It be direction from the court.
No, they will come voluntarily.
Please, my lord, please.
Difficult to correspondence with them.
No, that instead of directions, you give that one
Yes, yes.
photograph.
Please,
You give the photographs and
cooperate.
you identify that.
we'll cooperate.
Yes.
Please.
Leaves
Interim
this
order.
matter after 2 weeks. Interim order granted earlier is extended till next date of hearing.
Please.
Cell number 4, Kemparaju for petitioner, Murali PS.
Applying for the petitioner, my lord. My lord, the matter was referred to mediation. On 3 occasions, my lord, the respondent husband did not come. Hence, mediation failed, my lord. This court,
Mediation
my
is
lord,
failed.
failed.
Mediation report dated not settled.
On 3 occasions, my lord, this honorable court on dated 19/7/24 referred the matter to mediation, my lord. On 3/8/24, we went to mediation
Now,
center.
what is the matter?
My lord, this is a petition filed by the wife, my lord. Wife, my lord,
Yes, where is your opponent? Password.
has.
Yes.
Serial number 5, Suresh P, MM Anjaya Shetty for petitioner, Sandhya Jamadagni.
Appear for the respondent in this matter, my lords.
Yes.
I am petitioner.
Hmm.
The petitioner filing present petition seeking transfer of the MC petition number 50/23 pending before the Honorable Senior Civil Judge and JMFC Yadgiri to Family Court, Bangalore. As per the direction of this Honorable Court, my lord, I have produced the documents and copy also I have furnished to the respondent also.
What is that?
Documents.
Which is the case you want to transfer, mister?
Yadgiri to Bangalore Principal Court.
What is the case filed by the whom? Who has filed? Husband has filed.
Here, Bangalore Principal City Family Court, the petitioner has filed conjugal rights. MC number 62/22/23.
ಅವ್ರು ಯಾವ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದಾರ್ರಿ?
ಅಲ್ಲಿ ಡೈವರ್ಸ್ಗೆ
ಯಾದಗಿರಿಲಿ.
ಯಾದಗಿರಿಲಿ
ಕೇಸ್ ನಂಬರ್
50/23. MC number 50/23. Pending before the senior civil judge and CM CJM Yadgiri.
Filed by the wife.
ಅಲ್ಲ, ಇದು ವೈಪ್ ಹಾಕಿದ್ದು conjugal rights.
Where she has filed the conjugal right?
Family Court, Bangalore.
In that case, respondent husband is appeared.
Yes.
He has
Yes,
appeared.
I am here for the respondent, my lords.
Yes.
We have an objection to this. We have an objection to this because, my lords.
Wait,
Even to-
madam, he has not yet completed.
Yes, sir. Yes, sir.
You use that mic, mister. Mic ಸರಿ ಇದೆನಾ ನೋಡ್ರಿ. ಅಲ್ಲ, ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು ಅಪಿಯರೆನ್ಸ್. She can't identify that he is arguing. Yes.
I have filed the MC number 62/25/22 under section 9 of the Hindu Marriage Act.
Now that, what is the distance between that Yadgiri?
485 kilometers.
485 kilometers.
By bus 13 to 14 hours journey, and by train 10 hours journey.
Due to marriage, any children?
No issues.
Yes, no issues there.
No issues.
Then what is that wife doing there in that Bangalore?
He's
Is she working?
internship course. She was engineering student, unemployed.
He is residing with whom?
Bangalore only.
No, with whom?
Rented house. For completing as a internship course.
ಯಾರ ಜೊತೆ ವಾಸವಾಗಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತಾರೆ.
Single ಇದ್ದಾರೆ.
Yes, madam. What is your
Yes,
submission?
yes, my lords. It is a matter of jurisdiction, my lord. Jurisdiction, my lords. These petitioners and respondents have never lived in Bangalore or last resided in Bangalore as husband and wife, my lords. The petitioner now is claiming a copy of internship offer letter dated 4/3/2024. My lords, this petition was filed for restitution was filed by them in the year 2022 seeking for restitution. At that point of time also, they were not living together because they have issued a notice to us regarding restitution on 4/4/2022. The petitioner issues a notice to the respondent seeking for restitution and maintenance at his place of residence in Yadgir. And she also says that
under section 24 of that CPC,
yes, my
question
lord.
of jurisdiction would not arise as it is only a convenience of the parties.
Exactly, my lords. If at all tomorrow, my lords, this matter for divorce is presented before this court, I am already objecting to the restitution of conjugal rights case in Bangalore for the simple reason of jurisdiction itself. Then again, if this
Madam, from 2022, what has happened to that your objection?
2022, my lords, we had filed our written statement. Subsequently, my lords, matter was being heard about the maintenance, my lords. Maintenance was granted. Now it is posted for evidence. We are arguing the matter, saying that jurisdiction is not there. On the next date of...
No, first point has to be decided on jurisdiction. If it is point of jurisdiction has been raised.
Yes, my lords, I had to file an application regarding that on the last occasion, but my client now could not travel from Bangalore, from his Yadgir to Bangalore. On that occasion, applications are ready. We will file it on the next date of hearing in that matter. But as far as our original, our divorce petition is concerned, my lords, it is proper and it is the jurisdiction is there. Marriage happened there.
No,
Both
madam,
the
jurisdiction will not be the issue under 24. If you
My
have
lord,
raised a jurisdiction in that case filed by that wife, you could have get it disposed of from 2 years. It is pending.
Sir, it is because the petitioner was seeking for maintenance and we were opposing that. Subsequently, as per the Supreme Court guidelines, we had to file our application and everything, and it took a long time. It is not that 4/4/2022 they had initially filed one. After that, they had filed one petition, my lords, MC number 314 of 2022 in Bangalore, which was withdrawn by them for the want of jurisdiction itself, my lords. Maintainability melene adana withdraw ಮಾಡ್ಕೋಬೇಕಾಯ್ತು ಅವರಿಗೆ. Subsequently,
no, you forget all these things. Now the case is there. You have not filed an application from 2022. You are allowed the court to be proceeding for if there is court has no jurisdiction, it has to be dismissed this threshold. You are allowed for 2 years. Then you are saying that.
Swami, 2 years agಲಿಲ್ಲ. 2 years ಕಿಂತ ಮುಂಚೆನೇನೆ 2 years ಆದ್ಮೇಲೆ the matter.
Whatever you want to do it by next week, madam.
Yes.
If you want to get it decided application there, otherwise we will hear this matter finally. Yes.
Maybe taken up after vacation, my lords, because date ಕೊಟ್ಟಿಲ್ಲ, ಅದು date long date ಹೋಗಿದೆ.
Yes, leave this matter. You
order may be extended
by preponing and file an application, madam. If it is not maintainable, you are dragging for 2 years.
Last date of hearing, they have not appeared before the family court.
When the matter is called, you are not appeared. That is what their this thing.
Sir, ಇಷ್ಟು ವರ್ಷದಲ್ಲಿ ಒಂದೇ ಸತಿ appear ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
At the request of counsel for the
interim order may be extended.
As a last chance, leaves this matter after 2 weeks. Interim order granted earlier if any is extended till next date of it.
Serial number 6, Bhushani Kumar for petitioner, Shekharappa.
petitioner in this matter. My-
Yes.
In this matter, my lord, the respondent had filed a section 9 petition before Shumoga. Now that restitution petition has been dismissed. Now he has filed a divorce petition before on JMFC Chalkere Chitradurga. And I have a daughter who is aged 3 years and 125 proceedings is pending before family court at Shumoga.
You are
So I-
residing in Shimoga.
Yes, I am residing at Shumoga.
No, where is that now? Husband has filed in a case.
At JMFC Chalkere.
You have filed civil miscellaneous 155. It is pending. Chalkere in the Shimoga, what is the distance, madam?
Chalkere to
110 kilometer ಆಗುತ್ತೆ sir.
Huh?
110.
110.
110. Then it's male or female child?
Female, girl baby,
Yes.
3 years old child.
Yes, yes, mister.
My lord, respondent is a employee of the private company, my lord. One pay the alliance, my travel charge ಕೊಡ್ತೀವಿ sir. Travel
ಅಲ್ಲ ಅವ್ರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಇರೋದು ಮಗು ಇದೆ ಕರ್ಕೊಂಡು ಟ್ರಾವೆಲ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
ಆಗಲ್ಲ ಮತ್ತೆ
Not that
ಬೇರೆ
financial
ಕೇಸ್ಗಳು
logistics.
ಅಲ್ಲೇ ಇದೆ.
Yes, that's all.
disposal, speedily disposal within the 3 months. My conjugal rights petition is allowed, not come.
ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್.
ಯಾರು ಹಾಕಿದ್ದು?
ಅವರೇ ಹಾಕಿದ್ರು ಶಿವಮೊಗ್ಗ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Yes. So and so learned counsel appearing for petitioner wife has contended that after that matrimonial dispute, she is living with her parents in Shimoga along with her 3 years old girl child. She has filed civil miscellaneous 155 of 2021 for maintenance before family court Shimoga. ಅದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದಾರ ಅವರು?
appear ಆಗ್ತದೆ, maintenance ಕೊಡ್ತಾ ಇದ್ದೀವಿ sir.
In that case, respondent has appeared through counsel in prosecuting the case. The respondent husband has filed MC 50 of 2024 before Principal Senior Civil Judge Chalkere for dissolution of marriage. From Bangalore to some Shimoga to Chalkere, it is about 110 kilometers. It is inconvenience for the petitioner to go to Chalkere along with her 3 years old child for prosecuting the case. Hence, he sought for allowing that civil petition. Per contra, so and so learned counsel appearing for respondent has contended that respondent is resident of Chitradurga. He is working in private company. He will not get leave to go to Shimoga for prosecuting the case. It is inconvenience for him to go to Shimoga. Hence, he sought for dismissal of the petition. Heard the learned counsel for the parties peruse judgment and award. Peruse that civil petition paper. It is not in dispute. Petitioner is legally wedded wife of respondent. Their marriage was solemnized on 10/11/2019. Due to wedlock, a girl baby was born. Now she is aged about 3 years. After the matrimonial dispute, petitioner residing with her parents in Shimoga along with her 3 years old daughter. She has filed GNWC ಬೇರೆ ಹಾಕಿದ್ದೀರಾ ಏನಾಯ್ತು?
DNWC settled, my lord.
ಅದು ಲೋಕ ಅದಾಲತ್ ಮುಂದೆ ಸೆಟ್ಲ್ ಆಯ್ತು.
In case I'll raise. What is that CMS you have filed?
CMS is 155 of
Filed
2020.
CMS 155 of 2021 before family court Shimoga for maintenance. In that case, respondent has appeared and prosecuted the case. The respondent husband has filed MC number 50 of 2024 before senior civil judge Chalkere for dissolution of marriage. From Shimoga to Chalkere, it's about 110 kilometers. It is inconvenience for the petitioner to go with prosecuting the case in Chalkere. Considering that inconvenience made out by the petitioner and judgment of this court, civil petition required to be allowed. Accordingly, CP is allowed MC number 50 of 2024 pending in the file of Senior Civil Judge JMFC Chalkere is withdrawn. Same is transferred to family court at Shimoga. The family court is directed to dispose of that MC petition not later than 1 year from date of receipt of copy of this order. It is made clear that parties has to cooperate for early disposal.
Serial number 7, R.B. Sadashivappa for petitioner, Raghu Prasad B.S.
The respondent in this matter, my lords.
Yes.
May I please, my lord?
Yes, Mr.
Wife's petition, my lord, seeking transfer of the case from Family Court, Bangalore to Tumkur Family Court, as she is resident of Tumkur.
Who?
In addition to that,
No,
wife-
that husband has filed case for dissolution
yes,
in Bangalore.
please,
Wife is residing in Tumkur,
Tumkur. She is a resident of Tumkur.
resident of, she is residing with parents or
Parents.
due to wedlock, any issues?
Wedlock issues.
ಮಕ್ಕಳಿಲ್ಲ.
Only 125 proceedings ಹಾಕಿದ್ದಾರೆ Tumkur.
Ali, in that he has appearing. Yes. What is the distance between Tumkur and Bangalore?
About 78 kilometers.
70 kilometers. Yes,
Sev-
madam.
78 kilometers.
He's not working, he's working in Bangalore, my lord.
Who?
Husband is working.
Yes.
Residing in Bangalore, my lord. And there are other cases also pending, my lord. So
What is that other cases?
there are certain harassment cases and criminal cases also pending, my lord.
Pending where?
You are in Tumkur, one is in CCTV.
Yes.
So we offered them for the settlement. If they are willing to settle, then settle and close the matter, my lord.
We'll refer that mediation once.
Because instead of again traveling.
Please, please.
Yes.
For settlement, we have no objection for any
Yes.
case.
At the request of the parties, refer this matter to Bangalore mediation. Bangalore mediation center, Karnataka Mediation Center at Bangalore. Parties are directed to be present before Karnataka Mediation Center at Bangalore on which date? 21.
Immediate, my lord, after mediation, my lord.
We'll have it on 25th. 25th.
See, continue.
Stay continuous, stay.
Interior order may kindly.
Interim order granted earlier is extended till next date of hearing.
Great.
Serial number 8, Prakash M.H. for petitioner, Avinash B.
In this, I appear for
For
response.
the petitioner, your lordship, I seek for a short accommodation.
Objections and the application for vacating stay.
I've-
ready.
I've
And it is
just-
permitted file today. ma'am.
Yes, so after service,
Sir.
yes.
I've just
File
received
it in
it.
the counter.
Please.
Yes. At the request of the parties, leave this matter of 2 weeks.
Date may be given, my lord, because, my lord, here we have succeeded conjugal rights, my lord.
Yes.
And they have
14th
not failed to appear, they have failed to appear.
14th October.
Bless your lordship.
Gratefully.
Serial number 9, Jai Kumar ND for appellant, petitioner, Chandrasekhar R.
For the petition. Yes.
Lords, both parties are residing in Bangalore. The marriage took place in Kolar, but they were residing in Bangalore after marriage. He had an affair with one of his colleagues, so the wife confronted him. He left the house. After leaving the house, he's gone to Kolar, KGF, and filed a divorce petition. Lords, on the 10th of this month, the wife came to know that he's staying at a PG in Bangalore.
Oh.
So the husband is staying at a PG in Bangalore. So the wife goes there to confront him, and she realizes that he's staying with that lady there. Then she goes to the police station and files a complaint. And NCR is registered, showing that the husband, my lord, Sharat Kumar, is staying at Urban PG, Bangalore City.
Yes, mister, you are residing there. Even then also,
No,
you are
no, my lord,
assuming that you are not
it
residing. but
is
it's a
not
con-
correct. The submissions made by the learned counsel is not correct. I am the resident of KGF. And I am a resident of KGF. All the allegations what they have made, it is only to harass the respondent,
Any
my
of
lord.
that wife is residing in Bangalore.
The wife is residing, it is their case that wife is residing in Bangalore. My lord, after me filing a divorce petition in KGF, where it is a native place of both the parties. Now she is residing in KGF, my lord. I'll file my detailed objections in that regard.
Yes, if
My lord,
File my detailed
he is
objections.
employed in Bangalore.
Yes,
He
my
is a-
lord,
Siemens company.
Now
Illే
that-
Bangalore residing go. He's
My lord,
employed
he
in
is
Bangalore.
residing in
He's working in Bangalore.
he is working in Bangalore. I have no objection for that. But he's traveling KGF in the Bangalore. It is in Sajapur Road. It is 1.5 hour by train.
I think you are objection ಹಾಕಿನಿ.
Now objection ಆಗ್ತದೆ sir.
With this also you can file an
ಹೌದು,
objection.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ sir.
Also said she is also residing in that Kolar. She is not residing in Bangalore. That's what you are saying.
That was I was instructed.
You file that, let us see.
The
Yes.
house purchased by him, there is a loan. She was residing there. When she confronted him, he left the house. She is still residing there in Bangalore.
Let us see what will be that.
I'll
Let it
file
be
my
on that
objections.
writing.
Please.
Then we can.
Yes.
Yes.
I'll file my.
Any short date.
At the request of counsel for.
No, I have to file the objections. Okay, after vacations I release one.
ಆಗ್ಲೇಬೇಕ್ರಿ ಅದು ವೆಕೇಶನ್ ಮೇಲೆನೆ ಹೋಗುತ್ತೆ 2 weeks ಎನಿ ಶಾರ್ಟ್ ಅಂತ ಅಂದ್ರು. Why do you want for years? Yes.
The interim order may be extended.
Lease this matter, learned counsel for the respondent prays 2 weeks time to file objection. Lease this matter after 2 weeks. Interim order granted earlier is extended till next date.
Oblige.
Rajab, sorry to intervene. Serial number 8, interim order may be extended.
Serial number 10, Namita Mahesh BG for petitioner, Bimbadar HM.
Wife's petition, madam. Seeking for a husband has filed an application for restitution of conjugal rights, my lord,
Yes.
before the Sagar court, my lord. She is presently residing in Chilur village, Davangere Taluk, Davangere district, my lord, which is about 100 kilometers from Sagar.
Yes.
And she is residing with her parents. Father is blind, my lord. She has some health related problems. Medical records have been produced by me, my
Due to
lord.
wedlock, any issues?
No issues, my lord.
Yes.
My lord, by
Now that,
typographical mistake,
Has she filed any case in that
no, my lord.
Davangere? She has not filed.
My lord, by typographical mistake in para number 5 of my petition, my lord.
Hmm.
It is submitted petitioner has a child which is born on so and so. That is a typographical mistake, my lord. I may be permitted to delete that sentence, my lord.
Yes.
Para number 5, ground number 5 ali. There is one sentence.
You file a memo?
I shall, my lord. I shall file a memo, my lord.
Yes, Mr.
My lord, that is my first ground of objection, my lord, that absolutely from out of marriage, my lord, there are no child, and if there is any child for the petitioner, my lord, it is not, my lord, however, that is not available for me now. And nextly, my lords, it was a clear allegation against the respondent here in my lords that was made that he has mentioned a wrong address while filing the petition. Produced at page number 8, annexure A, page number 8. My lords, wherein I have clearly stated Chiluru Gramada Vasi, Shumoga Taluku, Shumoga Jilla. My lords may kindly see this Chiluru village was, my lords, earlier was within the jurisdiction of Shumoga district. However, my lords, in the year 2018, Namti Taluk was made, my lords, and thereafter it was Namti Taluk. However, this has not been considered by the respondent while filing this petition, my lord. That is the mistake that he has
filed it in 24.
Please, my lord. What?
Foral ನೀವು ಅದನ್ನ ಶಿವಮೊಗ್ಗ ಜಿಲ್ಲೆಗೆ ಸೇರಿಸಿದ್ರ?
No, my lord. That was out of his mind. ಹೊರತಾಗಿ ಅದ್ರಲ್ಲಿ ಬೇರೆ ಯಾವುದೇ intention ಇಲ್ಲ.
But admittedly, she is in Davangere now.
Yes, my lord, her Aadhaar card is also.
Chiluru village. And nextly, my lord, kindly see, it was the clear ground, my lords, made out by the petitioner that traveling is the difficulty for her from Chilur to Sagara. It is around 100 kilometers. I do admit, my lords, it is 100 kilometers. But if the traveling is problem, my lords may kindly see the distance from Chiluru to Davangere, to which court the petitioner is seeking transfer of this matter, is, my lords, situated at a distance of 66 kilometers. However, my lords, the distance from Chiluru to Shumoga, which has got a dedicated family court, my lords, is only 22 kilometers. So it may be transferred to Shumoga family court, my lords. It is situated within the distance of hardly 22 kilometers, and my lord, the petitioner is a resident of Shumoga town now, even now.
No, my lord, she is
That
not
is the reason
residing
which,
in.
my lord, she had left the house of the respondent. She need to work, and she is willing to work at Shumoga.
That document to show that she is resident.
My lords, I don't have any document, my lords.
Then how can?
Even then, my lords, the distance between Chiluru to Davangere, if it is considered with Chiluru to Shumoga, my lord, Shumoga is very much near. It is just within 22 kilometers from Shumoga.
From you are resident of Sagar.
Please, my lords.
Sagar to Shumoga, what is the distance?
My lords, it is 75. From Sagara to Davangere, it is 160, my lords.
Then you can, at least one of them will get in this thing.
ಇಬ್ಬರಿಗೂ ಅನುಕೂಲ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಶಿವಮೊಗ್ಗ ಆದ್ರೆ ಇಬ್ಬರಿಗೂ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಅವರಿಗೆ 22 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ, ನನಗೆ 75 ಕಿಲೋಮೀಟರ್.
Chilur village is in Davangere Taluk, Davangere district.
Forget about that district and this thing.
Please, madam.
Shumoga is convenient for you. You get
No,
that
madam.
instruction.
I'll get instruction. Shimoga is not convenient for her, my lord. Earlier, when she was residing along with the respondent,
No.
for some time she was working in Shimoga.
Yes,
She
saying
does not
that
have a residence in.
in Chellur.
Please, my lord.
There is no court in Chellur. You have to come to Davangere.
Yes, my lord.
My lord, sir, let me file the, please.
Now you have to come to Davangere. What is the distance between the Chellur to Davangere?
My lord, it is about 30 kilometers is my instruction, my lord.
My lord, sir, by Google, I could make it out, my lord. It is 66 kilometers.
I will verify that distance, my lord.
If that is the case, if Shimoga is nearer than that this, it is convenient for you. You also get an instruction from me.
Please, my lord.
Yes, at the request of the parties, leaves this matter after 2 weeks.
My lord, it may be called on the 1st of October, my lord. It can be disposed of.
Yes, 1st of October.
30th ಆಗ್ಬೋದು. 30th, my lord.
My lord.
30th, you can get the instruction.
My lord, I'm sorry, my lord, because I'm a government advocate. 30th is my writ appeal day, my lord. For that, before the division bench. For that reason, I'm requesting for Tuesday, my lord.
Yes, Mr.
All right.
Tuesday. Let us
Obliged.
see on that day. If there is otherwise, I will grant time.
Obliged. My lord, interim order may
If
kindly.
interim order granted earlier is extended till next date of hearing.
Obliged.
Cell number 11, Arvind H for petitioner, Suresh.
My lord,
I am for the
discuss on
respondent.
the petitioner, my lord. The petitioner is seeking, my lord, transfer for petition filed by the respondent husband from Davangere to Huvinadagli. And my lord, for a moment, my lord, kindly take note, page number 14, my lord. The petition filed by the respondent, page number 14, paragraph 13, my lord. On 2 proceedings, my lord, the respondent already appeared before the Huvinadagli.
Page number?
14, my lord, paragraph 13, my lord.
What is this?
That is,
You
my
have
lord, this.
filed in a criminal miscellaneous.
Yes, 498 and Dowry Prohibition Act. My lord, 2 proceedings he has already appeared before the Huvinadagli.
Criminal miscellaneous 581 of 2023 for what?
My lord, it is, my lord, 498.
The DV Act.
DB Act.
DV Act.
DV Act. It is pending in which court? Civil judge?
Yes, my lord, Huvinadagli.
Senior division or junior division?
It is junior division.
Junior.
Can't transfer there. Senior, now that what is your prior?
Senior division,
498 is also one of.
Number so and so senior civil judge JMFC. Yes. Now that husband has filed an MC.
MC, my lord, for seeking divorce.
Divorce,
Please.
187. In that criminal case and DV case, he is appearing.
Yes, my lord, he has already appeared.
Then we'll transfer. It's inconvenient for me. Yes. So and so learned counsel appearing for. Claimant has contended that. What is the distance between
70.
After the matrimonial dispute? Due to wedlock, any issues?
No.
No.
The petitioner residing with her parents in Huvinadagli, Taluk, Vijayanagara district. She has also filed criminal miscellaneous 581 of 2023 before Civil Judge JMFC Huvinadagli under DV Act. In that case, respondent has appeared through counsel and prosecuting the case. Respondent has filed MC number 187 of 2024, dissolution of marriage before family court
Please.
You have any instruction from the client that you have no objection or you want to
No,
pass in a very?
mother, age-old mother is here.
Yes. Counsel appearing for the respondent has contended that the respondent is residing with her age-old mother. He has to look after her. It is inconvenience for him to go to Vinadigalu to prosecute the case. Hence, he sought for dismissal of the petition. Heard the learned counsel for the parties. Peruse civil paper. It is not in dispute. Petitioner is the legally wedded wife of respondent. Yavaga madve agiddu? Their marriage was solemnized on 8/6/2022. After the matrimonial dispute, petitioner residing with her parents in Huvina. She has also filed criminal miscellaneous 581 of 2023 before civil judge JMFC Huvina under DV Act. In that case, respondent is appear through counsel and prosecuting the same. Respondent husband has filed MC number 187 of 2024 for dissolution of marriage before family court Davangere. From Davangere to Huvinadagulu, it is about 70 kilometers. It is inconvenience for the petitioner to go to Davangere for prosecuting the case. Considering that inconvenience made out by the petitioner and in view of judgment of this court, civil petition is required to be allowed. Accordingly, CP is allowed. MC number 187/2024 ending in the file of family court at Davangere is withdrawn. Same is transferred to senior civil judge JMFC Agri Bommanahalli Veterinary Court sitting at Huvinahadigilu, Vijaypura district.
Vijayanagara.
Vijayanagara, my lord.
Vijayanagara, yes. Vijayanagara district.
Macho.
Great.
Number 12, Arshita B for petitioner, SP Annegowda.
I appear for petitioner.
The
my lord.
respondent in this case, my lord.
Petitioner is seeking transfer of the divorce petition filed by the husband from Bengaluru to Hassan, my lord. The respondent is contending the maintenance case filed by the petitioner at Hassan, my lord. The petitioner is permanent resident at Hassan and she's looked after by her parents, my lord. Both the parents are working, my lord. The petitioner is not working, my lord. And no issues have been arised out of the wedlock, my lord.
Now that you have filed in a criminal miscellaneous for what?
Maintenance case.
For maintenance.
Maintenance case has been filed, my lord.
Already into maintenance has been granted, my lord, 10,000 rupees, my lord. The respondent is residing in
It's maintenance case.
It is before Hassan.
Hassan family court.
and one more petition also filed, my lord, 498A. It's also B report has been filed by the police.
Petitioner is
And to-
challenging the B report, my lord.
Now MC number 3323
2/3 of 24.
filed by that husband.
Husband,
Hassan to Bangalore, what is the distance?
182 kilometers, my lord.
Due to wedlock, any issues?
No issues, my lord.
Yes, Mr.
One submission, my lord. I have no objection to transfer Bangalore to Hassan, my lord. Our time may be fixed, my lord, 6 months. It's a many petition is pending, my lord, 498A and SIM is
Hassan, it's convenient for you, yes.
say very far, my lord, so that he's working in Bangalore. Time may be
In
fixed.
Bangalore, parents also reside with.
Please, my lord, Bangalore.
So and so learned counsel appearing for petitioner, wife contended that after the matrimonial dispute, she is residing with her parents in Hassan. She has filed criminal miscellaneous 86 of 2023 before Family Court Hassan for maintenance. In that case, respondent has appeared and prosecuted the same. Respondent has filed MC number 3323 of 2024 before Third Additional Family Judge Bangalore for dissolution of marriage. From Bangalore to Hassan, it's about yesterday
190 kilometers.
182 kilometers. It is inconvenience for the petitioner to come to Bangalore to prosecute the case, sought for allowing that CP. Learned counsel appearing for respondent has contended that respondent is resident of Bangalore. He is working in a private company.
Please, my lord.
He will not get any leave to go to Hassan for attending the court. And he has to look after his age-old parents.
Please, my lord.
Therefore, it is difficult for him to go to Hassan and sought for dismissal of the appeal petition. Heard the learned counsel for the parties. Perose judgment and Perose civil petition paper. It is not in dispute. Petitioner is the legally wedded wife of respondent. Their marriage was solemnized on 27/4/2023. After matrimonial dispute, petitioner residing with her parents in Belur, Hassan.
Hassan city, madam.
In Hassan. She has filed criminal miscellaneous 86 of 2023 for maintenance before Family Court Hassan. In that case, respondent was appeared and prosecuted the same. Respondent has filed MC number 3323 of 2024 for dissolution of marriage before Third Additional Family Judge Bangalore. From Bangalore to Hassan, it's about 182 kilometers. It is inconvenience for the petitioner to come to Bangalore to prosecute the case. Considering that inconvenience made out by the petitioner and judgment of this court, civil appeal is required to be disposed of. Required to be allowed. The MC number 3323 of 2024 pending on the file of Third Additional Principal Judge Family Court Bangalore is withdrawn. Same is transferred to Family Court at Hassan.
First additional, my lord, is a SIM is criminal miscellaneous pending ಇದೆ. First additional family court.
Yes, First Additional Family Court Hassan.
Please, my lord.
The Family Court is directed to dispose of that civil MC number 33203. No, since there are two cases,
please
dispose of the cases as expeditiously as possible.
Time may be fixed, my lord.
ಎರಡು ಕೇಸ್ ಇರೋದ್ರಿಂದ it's difficult.
ಸಿಮಿಸಲ್ ಡೈರೆಕ್ಷನ್ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರಿಗೆ. ಬೋತ್ ಪಾರ್ಟೀಸ್ ಆರ್ ಕೋಪರೇಟ್ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಅವ್ರು ಕೋಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ, my lordship.
Early disposal not later than 1 year from date of receipt of the copy of this order. Parties are directed to assist early disposal.
Grateful, my lord. Obliged.
Bill number 13, L Raja for petitioner G1K
This case appear by petition. Wife filed the petition, Bangalore to Mandya Maila. The respondent filed the MC petition, conjugal rights. His 1.5 years child is there, Maila. He is housewife.
You are in Mandya.
Mandya.
Yes, husband has filed in a case for what? Restitution of
Conjugal
conjugal.
rights.
You have filed any case?
No, my
Wife has not filed.
might not filed.
MC 4129 of 24 ಏನಕ್ರಿ?
ಇಲ್ಲಿ
that is
ಬೆಂಗಳೂರು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್. ಬೆಂಗಳೂರು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್. ಇಲ್ಲಿ ಓನ್ಲಿ ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಇರೋದ್ರಿಂದ ಒಂದು ಚಾನ್ಸ್ ಒಂದು ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡಿದ್ರೆ then we will try because ಅವರು
Yes, once we'll refer that
ಅಲ್ಲ
mediation.
ಮಂಡ್ಯದಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾಕೆಂದ್ರೆ ಒಂದೂವರೆ ವರ್ಷ ಮಗು ಇದೆ ತುಂಬಾ ಕಷ್ಟ ಆಗ್ತದೆ.
ಆಯ್ತು, ಮಂಡ್ಯಕ್ಕೆ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡೋಣ, ಮಂಡ್ಯ ಡಿಸ್ಟಿಕ್ ಕೋರ್ಟ್ಗೆ.
ಹಾ ಅಲ್ಲ ಆಗ್ಲಿ ಮಂಡ್ಯ.
Yes. At the request of the parties, refer this matter to Mandya District Court Mediation Center. Parties are directed to appear before the Mandya Mediation Center when it is your convenient.
Yes, Saturday, third Saturday of October.
26th, third Saturday. Yes. Again, 26th. Again, yes, directed to appear before Mandya District Court Mediation Center on 26th.
Entry order action.
Interim order granted earlier is extended till next date.
Serial number 14.
Before the
Move
petitioner in
to
this
the
part,
bench for petitioner.
before the petitioner in this part, Lordships, you have filed the civil petition seeking transfer of the matrimonial case from Bangalore to Davangere, Lordships. Lordships, the facts of the case, the petitioner and the respondent got married in the year 2020, Lordships. Now, since 2021, they have been separated, and since 2021, the petitioner has been staying in Davangere. Now, Lordships, the
So
petitioner.
wedlock, any issues?
No issues, Lordships. There are no children out of the wedlock. Now, Lordships, both the petitioner and the respondent both belong to Davangere, Lordships. Now, the respondent is the restitution of conjugal rights. Both the petitions have been filed, and it's at the stage of summons, Lordships.
Yes, heard. Issue notice. Stay of further proceedings in MC number 4374 of 2024. Pending on the file of second additional principal judge family court at Bangalore till next date of hearing.
Grateful, Lordships.
Serial number 15. Dudwat Sarash Chandra for petitioner.
My lord, I am appearing for the petitioners. My lord, wife is before my lords. My lord, seeking the transfer of MC petition filed by husband at Dharwad. My lord, he has filed the MC petition for the dissolution of the marriage. My lord, wife has filed a petition in Bangalore under for the Domestic Violence Act.
Wife is also filed in a case for what?
My lord, he has filed dissolution of marriage in Dharwad. Wife has filed the petition for violation of domestic violence. My lord.
In Bangalore.
Please, my lord.
In that case, he has appeared.
My lord, in the Bangalore, he has appeared. My lord.
He has appeared.
He has appeared, my lord.
Yes. Due to wedlock, any issues?
No issues. My lord, 2015, marriage is solemnized.
Yes. What is the distance between Bangalore to Dharwad?
My lord, it's about 430 kilometers, my lord.
Yes, heard. Issue notice. Stay of further proceedings in MC number 267 of 2023. Pending on the file of Principal Judge Family Court, Dharwad till next date of hearing. Yes.
Serial number 16. P Nataraju for petitioner.
This case, my lord, the maternal grandparents of the petitioner have filed the petition under the guardianship and the Guardian and Wards Act before the senior civil judge at Hunsur. The paternal grandmother of the petitioner has filed a suit against the petitioner for the relief of injunction before the junior division judge Hassan, my lord. I am seeking transfer of the suit from Hassan to Unsur.
No, you are resident of Mysore, Unsur.
Unsur.
Who has filed this natural guardian? Grandfather,
Grandmothers, grandparents.
grandparents.
Houdu.
What about that parents?
Both the parents died.
Dead? Now, who is that respondent?
Lord, the respondent is the paternal grandmother of the petitioner.
Paternal grand.
She has filed a suit
Yes.
before the civil judge junior division of Hassan for the temporary injunction, for a relief of injunction or claiming pensionary benefits.
For what she has filed?
Claiming pensionary benefits
Pensionary benefit of whom?
of his son, of her son.
Of
Son
son.
was working in the military.
No, mother has filed
Yes.
Yes.
I'm seeking but there is a threat to the life of the petitioner and the grandparent. My lord. We have also filed the complaint before the jurisdictional police Hassan. Here the
Aito,
police have issued the.
ಅದು suit ಅಲ್ಲಿ ಏನಿದೆ, you have to give a consent. Why the suit is?
I don't know what is the merit.
No, see, you have no right to claim in a compensatory appointment.
ಅಲ್ಲ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದೇನು ಅಂತ ಮೆರಿಟ್ ಮೇಲೆ.
No, you said suit for what?
Suit for pensionary benefits.
Pensionary benefit.
ಹೌದು pensionary benefits and other benefits ಎಲ್ಲ ಇದೆ ಅದರಲ್ಲಿ. ಅದ್ರ ಮಿಲಿಟರಿ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಏನೇನ್ ಇರ್ತದೆ ನಮಗೆ ಗೊತ್ತಿರೋದಿಲ್ಲ, ಅದನ್ನೆಲ್ಲ ತಗೊಂಡು
ಇತರೆ ಸವಲತ್ತು ಒಂದನೇ ಪ್ರತಿವಾದಿ
ಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದ್ರೆ ನಾವು ಕೇಳ್ತಿರ್ಲಿಲ್ಲ ಅದೇನ್ ಬರ್ತಿರ್ಲಿಲ್ಲ.
Yes. Heard. Issue notice. Stay of further proceedings in YS number 364 of 2024, pending on the file of 5th Additional Civil Judge JMFC at Hassan. Till next date of hearing.
Much.
Bill number 17, Mahesh CM for petitioner.
Lord, appearing for the petitioner, my lord. The respondent husband has filed a petition for a dissolution of the marriage in Bangalore Family Court. The petitioner herein has completed her MBBS course from Bangalore and she got a government seat in Adi Chunchandagiri Medical College at Monday. Now she is studying her first year PG course in Monday. It is 3 years course degree, my lord. And college timing is 9
These
AM.
are permanent residents.
Permanent resident is in Bangalore only, but the college timing is my lord 9 AM to 4 PM. And weekly twice she has to attend the central lab duty. And weekend duty is there. Therefore, my lord, in post graduation, not a single day the vacation will be given to the students. That's the students' difficulty, my lord. The who completed MBBS, they want to do any.
What is that her husband is doing?
He is a software engineer working from home, based on a US company.
Yes. Working from?
Working from home, my lord.
Working from Bangalore only is residing.
Bangalore only residing.
Heard. Issue notice. Stay of further proceedings in MC number 2379 of 2024, pending in the file of 3rd Additional Principal Judge Family Court, Bangalore, till next date of hearing.
Much obliged. Much.
Serial number 18, Gurudeva Prasad KT for appellant, connected matter, S. Nagaraja, Ravi S. Samprati.
Yes.
Password.
Password.
Up in portal number 5.
Now, who is that S. Nagaraj? Ravi Samprati. Both are ready.
Please.
Yes, password.
Serial number 19, KT Gurudeva Prasad for appellant, D. Vijay Kumar. Serial number 19.
Please, my lord. Ready, my lord. I am ready.
Yes, what about that appellant? Gurudeva Prasad is ready. Next week. Yeno bari ida. Yes, password.
Serial number 20, Dayanand S. Patil for appellant, HS Lingaraj.
Case of injury, my lord.
ಲಿಂಗರಾಜ್ ಇದಾರಾ?
ಲಿಂಗರಾಜ್ ಅವರು ಒಕ್ಕಲತ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ 2 weeks ಟೈಮ್ ತಗೊಂಡ್ರು.
ಕೇಳಿದೆ. ಎಸ್.
ಅವ್ರು ನೋಡ್ರಿ ಒಕ್ಕಲತ್ ಹಾಕಿಲ್ಲ ಇರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ.
Out the request. Last time ತಗೊಂಡಿದ್ರಾ?
2 weeks ತಗೊಂಡಿದ್ರು ಸ್ವಾಮಿ ಅದು.
Did you meet him? Did you meet him that whether he has given any this thing?
ಇಲ್ಲ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಕೋರ್ಟಲ್ ಎಲ್ಲೂ ಕಾಣ್ಲಿಲ್ಲ.
Yes, ಲಿಂಗರಾಜ್ ಬಂದಿದ್ದಾರಾ ಮಿಸ್ಟರ್ ರವಿ?
ಬಂದಿಯಾರಂತ
Weeks time.
Weeks time. Yes, at the request of counsel for the respondent, please this matter next week.
Serial number 21, Jagadish HT for appellant connected matter, B Pradeep.
Appellant in this case.
ಯಾರು
Pradeep, ಅವರೊಂದು appeal ಇದೆ, ನಂದೊಂದು appeal.
ಅವ್ರದ್ದು ಅಪೀಲ್ ಇದೆಯಾ?
But ನಮ್ಮ ಕೇಸಲ್ಲಿ Pradeep is
Pradeep is directed to take notice for respondent number 2.
Please.
ಅವ್ರದ್ರಲ್ಲಿ ಯಾರಿಗೆ ಸ್ಟೆಪ್ಸ್?
Respond number 2, owner of the vehicle ಗೆ ತಗೋಬೇಕು ಸರ್.
ನೀವು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ರಾ ಇದ್ರಲ್ಲಿ?
ಅವನು ತಗೊಂಡಿಲ್ಲ. Respond number 1 I permitted to take out notice.
Minor represented by R2.
ಇಲ್ಲ, minor
ಕೊಡ್ರಿ.
minor. Respond number 2, the owner of the vehicle is this. Our appeal.
So since minor represented by guardian father Umesh PD.
Umesh, yes.
So since represented by S.
ಅಲ್ಲಿ R2 ಗೆ
R1 minor represented by R2 ಅಂತ ಏನ್ರಿ?
ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ.
Yes.
ತಪ್ಪಾಗಿದೆ.
Jagdish HD is undertake to appear for R1. Office is directed to show his name. R2 ಗೆ they have to take steps ಅಲ್ಲ?
ಹೌದು ಸರ್.
Weeks time is granted to pay the process, issue notice to R2.
Please.
Serial number 22, Gopal Krishna and for appellant C Shankar Reddy.
For appellant, my lord.
Ready?
Ready, my lord.
Yes, Mr. Reddy, ready.
Ready. Case of injury.
Date of accident, my lord,
Hmm.
29/1/2015. Injured was age 25 years, my lord.
Hmm.
Injury sustained is injury to right neck, that is injury to artery, axillary and artery.
Hmm.
Fracture of right radius and fracture of right scalpa and right clavicle.
Hmm.
Blunt injury to abdomen with liver contusion and apitorinum.
Hmm.
Head injury, fracture of nasal bone and maximilia.
Hmm.
Right bronchial palix injury with right hebrus palpsy. My lord.
Hmm.
50% disability to the whole body assessed. He was employed as a KSRTC and salary of rupees 19,650 per month he was earning, my lord.
Hmm.
First ground is that, my lord, the tribunal below ought to have awarded compensation for loss of salary for more than 2 months during treatment.
Now
at-
that he is continued in this
Continued his job. Continue. There is no loss of pay.
person of loss of earning.
But
So that fracture, pain and suffering 1 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ. Medical
no, my
expenses.
lord, 2 months he was under bed rest, my lord.
Yes,
So
so
that has to be
continuance,
granted, my
maintenance.
lord.
Maintenance has to be granted. Loss of comfort and amenities has to be enhanced. Loss of 2 months salary.
Yes, my lord.
Hmm.
So that has to be granted, my lord.
Now, why that he has not been paid that salary during that leave?
No, my lord.
Establish that.
Gopal Krishna and myself have gone through the papers.
Hmm.
5 months salary has not been given.
Yes, my lord.
5 months.
Yes,
Right.
my lord. So that has to be granted, my lord.
Why 5 months?
Because he was under bed rest, my lord, due to the injuries suffered.
Hmm.
He had neck injury and head injuries 1 to 4 are grievous in nature, my
Where is
lord.
that discussion of the court?
It
2
was
months
there in-
discussion ಎಲ್ಲಿದೆ ಅದು?
Yes, my lord.
Madi,
There in-
discussed Madi. It has not been discussed.
29,300 ಕೊಟ್ಟಿದಾರಲ್ಲ ಎಲ್ಲಿದೆ ಅದು ಡಿಸ್ಕಷನ್?
Para 14 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, but
Hmm.
regarding loss of salary ಅದೇನು ಹೇಳಿಲ್ಲ.
For case of petitioner, but in this case, there is no records indicate because of the above fracture injuries, claim is not due to his daily activities. Apart from that, exam clearly admitted before the student, he was, there is no records to indicate because fracture so and so.
My lord, in judgment, page number 19, it is stated, my lord, these documents also disclose that petitioner was undergone surgery for his fractured parts. The wound certificate discloses injuries number 1 to 4 are grievous in nature. Because of this, he was unable to attend to his work, my lord, for 5 months.
ಎಲ್ಲಿದೆ ಆ ತರ?
But discuss ಮಾಡಿಲ್ಲ, documents ಇದೆ. In fact, in ಲೋಕದಲ್ಲ, we discussed about this. They agreed to pay 3 months salary, but they are asking for 5 months.
ಅದೇ to grant 5 months, there should be some reference.
Documents
Records ಬಂದಿದ್ಯಾ?
Records ಬಂದಿಲ್ಲ.
Notice here has come, my lord.
Which is that records to show that you are
Notice here has come, my lord.
ಯಾವ್ದು records ಇದೆಯಮ್ಮ? To show that you have taken 5 months rest.
My lord, all medical evidences have produced, my lord. Disability certificate and exhibit P13, my lord.
I am asking that, which is that records to show that you have taken 5 months leave
Yes.
to take rest. ಎಲ್ಲೂ discuss ಮಾಡಿಲ್ಲ.
Discuss ಮಾಡಿಲ್ಲ. ಅದರ ಬಗ್ಗೆ
You have to show me that what is the records. Show that the claimant is treated inpatient from 21/1/2015, 27/2. Columbia asset, this claimant of compound so and so, depositor so and so, he has examined the petitioner with the history of the road accident. So petitioner treatment further P2 also stated that by analyzing the patient clinically and examinations of the right upper limb,
Judgment page number 22, my lord. Therefore, as per exhibit P10, petitioner has not received 2 months salary only. Therefore, claimant is entitled for this 2 months only, that they have stated, my lord.
for as per the exhibit P10, petitioner not received that P10 ಕೊಡಿ. 2 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ.
That's it, my lord. But remaining months he has not received, my lord.
ಎಲ್ಲಿದೆ ನಿಮ್ 5 months ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ? What is this exhibit ಏನ್ರಿ ಇದು? P10 ಅಲ್ಲಿ ಏನಿದೆ ಇದು? ಬಹುಶಃ ನಿಧಿ ಏನೇನೋ ಇದೆ ಅದರಲ್ಲಿ. How can you say that when you have not? Yes, madam.
Yes,
Paso.
Paso, my lord.
Paso. Let him come.
Paso next week.
No,
Next week.
Only Paso, my lord. My senior is held up in court all 5. He'll be coming.
You want next week?
Next week.
Yes. Leave this matter.
On Monday, my lord. Monday.
Not Monday. Vacation. After vacation.
ಯಾವಾಗ ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಆಗಲ್ಲ.
Monday, my lord. Kindly, my have to.
Either today or after vacation.
Okay, today.
Yes.
Yes. Much.
Serial number 23, Rajaram as for appellant, Ravish Penny.
Can respond.
Where is Rajaram? Password.
Please.
Serial number 24, Ravi S. Samprati for appellant, connected
Let-
matter.
There are 9 matters totally. In this, ಎರಡರಲ್ಲಿ MFA 4060 of 20 and 4097 of 20 ಇಬ್ರು ಎರಡರಲ್ಲಿ R1 ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
Serial number?
ಸೀರಿಯಲ್ ನಂಬರ್ ನಾನು ನೋಡಿ 4060 ಮೇಲೆ
4060.
4060 of 20 and 4097 of 20.
R1.
ಈ ಇಬ್ಬರಲ್ಲೂ R1 ಒಬ್ರೆ. ಐ ವಿಲ್ ರಿಕ್ವೆಸ್ಟ್ the same advocate has appeared on behalf of the claimants in other cases.
Claimants?
ಹೌದು, claimant.
ಯಾರು attend?
ಶಿವರಾಮ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
N. Shivram.
and I'll request him to take notice. I may be permitted to serve notice
Yes.
on.
24.2 N. Shivram is directed to take notice for R1. Counsel for the appellant is directed to serve one set of copies. Innondu 4097
4097.
Idrallu same. Aste. Yes.
Maybe it can be ಇದರಲ್ಲಿ ಏನಂದ್ರೆ negligence. I am the insurer of the car. The lorry was stationed on the middle of the road. The car goes and dashes against the lorry. 70% negligence is fixed on the driver of the car and 30% on the lorry. That is being questioned.
After vacation. Yes. Records ಬಂದಿದ್ಯಾ?
Records ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಬಂದಿದೆ.
Yes.
Office objection, first time matter, serial number 25, PM Sidamalappa for petitioner.
Yes. Sidmalappa? Yes, Pastor. What is that of subjection?
Sir, what to end this?
Yes, Pastor.
For order, serial number 26, adjourn, serial number 27, O Mahesh for appellant.
The last occasion.
I appear for the
Orders. Last occasion, 19th. On the same day, when the matter was listed before, we first write on the day of admission, we are seeking for stay of further proceedings of all the suits. It's a case of transfer under section 24. On the last occasion, we could not provide the particular suit number and it is decreed now. And today they have taken adjournment without informing us.
No, they said we'll inform you. Therefore, I have.
No, they have not. They have not even
taken adjournment.
Shriyari AV,
Huh?
8 and 9.
Yara?
8 and 9, Shriyari AV.
Shriyari AV has taken time.
They are there ready. I mean, they are connected.
Maintainability of the writ petition first has to be heard.
Yes, I will.
Anyhow, it has been urgent.
Pardon?
I have urgent already. Now I can't hear that.
Day after tomorrow.
No, next week ಅಂತ ಹೇಳಿದ್ದೀವಿ.
ಅಲ್ಲ, next week. we can-
14th October.
So in the meanwhile.
Civil criminal proceedings ಎರಡು ಕ್ಲಬ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅದು ಹೆಂಗ್
ಆಗತ್ತೆ, that I will convince. I already relied upon certain judgments.
It is not before me. Morning they have asked the time I have granted. I have asked them whether you have informed. He said, yes, we'll inform.
No, I have
He
not
said,
been
yes.
informed.
Do not.
Yes,
Please.
When, no, the further proceedings, ಒಂದು ಡಿಗ್ರಿ ಆಗಿ ಆಯ್ತು. No, it is.
I will 24th because in the presence of the council I have urgent. In his absence, then it's not proper. 14th or 15th?
15th it may be.
15th.
No, 14th.
15th. Yes.
15th.
This is how that lawyers are making in a submission.
And that to orders category.
Yes.
That's what on the last occasion, first occasion I relied upon the judgment and about that criminal, there is nothing. 138% could be clubbed because section 1.
See that,
Please.
Serial number
Because of the vacation, so they
Yes.
may try
Yeah.
to.
27, O Mahesh for appellant, Sandeep Pegde.
Sir, the paper publication has been produced
Agidya.
regarding respond number 2 and 3.
Yes. As per the directions of this court dated 31st/7/2024. This court has directed the appellant to take out notice to respondent number 2 and 3 by substituted service through Kannada daily newspaper, Samyukta Karnataka, Bangalore edition. Pursuant to that, the appellant has filed a memo enclosing that paper publication. Respondent number 2 and 3 called.
Respondent number 2, Prakash KS. Respondent number 3, Lakshmi Narayana.
None appears. Memo is accepted. Service of notice to R2 and R3 is held sufficient.
Serial number 28, Jeevan K for appellant, O Mahesh.
I appear for respondent.
Notice to R1 unclaimed ಅಂತ ಬಂದಿದೆ. Tribunal ಅಲ್ಲಿ liability and the respond number 1 only ಮೇಲೆ.
Yes, now we will service to be held. Yes. Notice issued to that respondent number 1 by this court is written with postal shara unclaimed. In service of notice to R1 is held sufficient.
Serial number 29, adjourned. Serial number 30, Hanumantappa for appellant.
Non-compliance of the office subsection raised on. Yes, Hanumantappa.
Serial number 30, Hanumantappa.
appeal was dismissed for non-prosecution. Same present application. One of 2024 entry.
Recalling.
Can't be entertained.
Yes, please.
Here 1 and 2 end. You can stay. Here 3 again is the office objection.
Recalling application file ಮಾಡಿದ.
Yes, none appear for the appellant. Leaves this matter of 2 weeks.
Serial number 31, O Mahesh for appellant, Muniappa D Naveen.
I appear for the appellant, my lord.
Hmm.
Pray for which time, my lord, it has been published, it seems that they have not sent a copy. To
Yes.
produce, my lord, which time I can.
Yes, at the request of appellant, leaves this matter next week.
Please.
Serial number 32, Sripad V Shastri for appellant, ICICI General Insurance.
Paper publication.
Sir. Acceptance.
Yes. This court by order dated 31/7/2024 permitted the appellant to take out notice to respondent number 1 by substituted service through Kannada daily newspaper Vijayavani, Bangalore edition. Pursuant to that order, appellant has filed in a memo enclosing paper notification, enclosing paper publication. Respondent number 1 is called.
Respondent number 1, Rajesha.
None appear. Memo is accepted. Service of notice to R1 is held sufficient. ICICI ಯಾರಿದ್ದಾರೆ?
ICICI General Insurance. ICICI.
A. Venkatesh. Yes. Respondent 2 is served on representative. A. Venkatesh is directed to take notice. Yes.
Serial number 33, Gopal Krishna N for appellant.
Appear for appellant in this case, my lord.
Hmm.
I'll take paper publication for R1, my lord, substituted service.
Address to issue notice to R1 for 3rd time.
Yes,
What has
my-
happened?
It's showing
Sufficient address.
You have to furnish correct address, madam.
he stays ex parte in MACT, my lord. It's a liability in question. I'll take paper publication, my lord.
Yes. At the request of counsel for the appellant, 2 weeks time is granted to do the needful.
Much
Serial number 34, Sripad V Shastri for appellant, Renuka HR.
Non-furnishing of acknowledgement correct address issue notice to R2 for 2nd time. Weeks time is granted to do the needful.
Serial number 35, O Mahesh for appellant, connected matter.
Yes, Mr.
Serial number
Mahesh.
35. Sir, mic mute agide.
Notice was sent to my lord, the same address given by them in the cost title of the MEC and deposition. Now the Shara is insufficient address.
Yes. What you want now?
A week's time to verify, my lord,
Yes, weeks time is granted to do the needful.
in both cases. my lord.
Yes.
Serial number 36, HS Lingaraj for appellant, Nagaraj S Jain, Chandra.
Yes, at the request, weeks time is granted to do the needful.
Serial number 37, NK Siddeshwara for appellant, B Pradeep.
Yes.
Serial number 37, NK Siddeshwara.
Yes, none appear. Leave this matter of 2 weeks.
Serial number 38, Rangegowda NR for appellant.
2 weeks time. Yes, at the request, 2 weeks time is granted to do the needful.
Serial number 39, Prakash MH for appellant, Janardhan Reddy.
For the appellant, your lordship, I may be permitted to take steps again because it is served.
Weeks time is granted to do the needful.
Oblige, your lordship.
Serial number 40, Arjan. Serial number 41, Sumant L Bharadwaj for appellant.
A week adjournment kindly may be granted, my lordship.
Serial number 41, Sumant L Bharadwaj.
Insurance company is not there.
Yes, my lordship.
Second
Insurance
respondent
company is there, my lordship.
You have to take
Respondent number
notice
1 and
for 1 and 2. To Reliance General Insurance Company. Reliance ಯಾರಿದ್ದೀರಾ?
Reliance General Insurance.
Ashok.
I will take notice, my lord.
Yes, Ashok and Patil is directed to take notice for R2. Counsel for the petition appellant is directed to serve one set of copies. Week's time is granted to pay the process, issue notice to R1.
Serial number
Yes. R1, you pay the process.
Please, my.
42, Vinod Gowda for appellant, BC Sitaram Rao.
Deemed to service, he has refused.
Not claimed.
Yes.
ಸಮುದ್ರ ಗೇಟ್ ಹತ್ತಿರ ಸೀಕೆರೆ ಕಡೆಯಿಂದ ಒಂದು ಇನ್ನೋವಾ.
Notice issued to that respondent. Number 1, written with postal shara, not claimed. In service of notice to R2 is held sufficient.
ಇದೊಂದು ಫೈಲ್ HDFC ಇದೆಯಾ ನೋಡು. ಫೈಲ್ ಇದೆಯಾ ನೋಡು.
Serial number 43, R Lakshmana for appellant, IFCO Tokyo General Insurance.
Lord, I am for appellant. Lord. R1 is the owner of the vehicle. R2 insurance company has certified the award amount. Lord. Friendly may be dispensed.
IFCO Toki are there.
IFCO Tokyo.
So to case Pradeep is there, my lord.
B Pradeep. Yes, B Pradeep is directed to take notice for respondent number 2. Internet counsel for that appellant has filed in a memo dispensation of notice to R1. Notice to R1 is dispensed. There is a delay of 28 days. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 28 days in filing an appeal is controlled. Yes.
Serial number 44, Abhishek Patil for petitioner, Chandan. Government
Respond
advocate.
number 6 in this case, my lord. The
petitioner.
dispute has been settled for mediation. Mediation report has come before you.
Report received from the Karnataka Mediation Center, Bangalore, stating that the parties have settled that dispute by way of mediation. Now you want to withdraw or you want to order in terms of the mediation?
Order in terms of the
In
mediation.
terms of the mediation.
Early the report. What is the settlement?
Settlement is, my lord, certain amounts has been paid to the petitioners.
Who is petitioner?
Petitioners are the legal heirs of the original landlord.
Landlord.
And
Grantee.
respond
Grantee.
number,
You are the grantee.
Yes, madam. My LR, madam.
LRs of the original.
Original grantee.
Original grantees.
You are the purchaser.
I am the purchaser.
Now what has happened to that AC? AC is dismissed.
AC has dismissed the application, my lords. Then,
DC
my lords, the petitioners went on an appeal before the deputy commissioner. Deputy commissioner also dismissed the appeal, my lords, challenging the DC's order, my lords, and before this honorable court.
Now you have settled that.
Settlement.
You have taken extra money and
Yes, ma'am.
yes.
Please.
then court has referred this matter.
Yes, madam.
Refer to the Bangalore. This court by order dated 5/8/2024 has referred this matter to Bangalore. It's actually Karnataka Mediation Center at Bangalore.
Yes.
Karnataka Mediation Center at Bangalore. The parties have settled their matter before that mediation center. We have received that report from the Bangalore Mediation Center. Really the report. Verification. Received that mediation report along with that letter dated 24/8/2024. The counsel appearing for the parties has submitted that this writ petition can be disposed of in terms of that settlement. Accordingly, the writ petition is disposed of in terms of settlement of the parties filed before that settlement as per that mediation report. Yes.
Please.
Terms of that will dispose of.
Please stop.
Because it cannot be extracted. It is more than 20 pages you have settled. Mediation report itself is there for 10-15 pages.
My lord, the
All
settlement
that,
terms is,
huh?
settlement terms is only 7 pages, my lord, with the schedule.
Yes, 7 pages.
7.
He need not again type. That's what we,
Yes,
in terms
please.
of that, yes,
Yes,
it is
but-
on record. We can take
Yes,
that.
much obliged, much obliged.
Notice is not complete.
My lord, notice in respect of, I think,
3
because
to
they
5.
are my vendors. My lord, respondent number
They are not necessary.
3, 4 and 5 are my vendors, my lord.
They are not
They
necessary.
are not necessary.
Respondent number,
3, 4 and 5.
early serial number ಎಷ್ಟಿದೆ?
Sir, 44, sir.
ಯಾರ್ಯಾರಿಗೆ ಆಗ್ಬೇಕು service?
3 to 5 service ಆಗಿಲ್ಲ, sir.
3 to
5, sir.
ಅದ್ರಲ್ಲಿ 3 to 5 are your vendor.
Yes, my lord.
Yes. Learned counsel for the petitioner has filed a memo
Please.
seeking dispensation of notice to 3 to 5. Yes.
Much, much.
Serial number 45, Murali BS for petitioner.
For the petition.
Hmm.
Not all objections are complied.
Hmm.
Not the office, my lord, with regard to prayer number A. But I have sought for declaration of the amended provision as unconstitutional. That's the.
Non-compliance of the office objection, counsel submission. What is that office objection?
I have stated, my lord, that the production of annexure does not arise when a declaration of a statute is sought to be.
What is the prayer?
Lord, prayer number 1, my lord, is to declare the amended provision as unconstitutional, and consequently, my lord, the other 2 prayers, my lord, to quash the orders of the assistant commissioner and the deputy commissioner.
You have to produce that copy of that amendment.
Not amendment, my lord, I have extracted, my lord, in the writ petition itself.
No, writ petition cannot be quashed, mister. It should be annexed to that petition which you wants to quash.
Not
You
the
can produce that Xerox copy in all, so many cases they have produced. In all cases, you produce the Xerox copy for quashing. What you want to quash, it should be in that part of that annexure. It is not seeking in a quashing of the pleading, mister.
Not the pleading.
Then if you say in that pleading,
I'm not seeking for quashing, to declare, my lord, that provision as unconstitutional.
that's what that, for that you have to produce that copy of that
My
notification.
submission was that it will be in the statute, my lord. If it is to be declared, my lord, it will be declared by the honorable court.
You
my lord.
produce one copy.
I will
In
produce.
all cases, they have produced
I will
that.
produce.
Take it as in a copy of this.
There's some urgency, my lord, that's the
You
reason.
produce it tomorrow itself, you will have it.
ನಾಳೆ ಬೇಡ ಸ್ವಲ್ಪ inconvenience ಇದೆ.
When do you want?
Friday, my lord.
Friday.
Friday.
Leave this matter day after tomorrow.
Serial number 46, Badrinath.
It be passed over, my lord, in the afternoon, I will file along with the memo.
Yes, pass on.
Please.
Serial number 46, Badrinath R for petitioner, R Lokesh.
I appear for petition. Page number 80, annexure E10, my lord. The internal page number is not given.
Respondent number 10.
Page number 80, my lord.
Non-compliance of the office objection.
Internal page number is not given, that is the office objection.
Petition copy to be served to that advocate for the caveator.
I have been served.
You are served.
I appear for respondent number 10, my lord.
Then a notary.
Third, I am filing the acknowledgement.
Yes.
The
Learned
office
counsel
objection.
for the petitioner has served the copy to that caveator. Yes.
Annexure E, page number 80, my lord. E10.
Are you
I am the purchaser.
purchaser?
Where the order passed by the second respondent is against a dead person, where I could
What is
not.
the grant?
Madam,
What is the date of the grant?
grant is of the year 1942.
42. Sale
First sale is on 1962, 16/8/1962,
62.
where again the second sale is on 17/4/1963.
What is that order of the TAC?
AC has been directed to restore the land to the original grantee. But that has been confirmed by the deputy commissioner in the second respondent. Where during the pendency of the second proceedings before the second respondent, where the respondent, second respondent had been died on 17/11/2017. I had produced the death certificate now here before.
Before whom? The DC?
Yes, before the decease.
Where is the DC order? Annexure?
Annexure here, page number 27.
Who has that?
Second respondent, Nagappa,
Kappa is the original grantee.
original, his grandfather is the original grantee.
And that LRs of the grantee. The order is against the dead person.
Dead person.
Now it
Sir,
has to go back.
I could not bring the legal heirs. They could not produce the legal heirs and death certificate before the
Now
second.
you made whom as a party here?
Then
Legal
I had
heirs-
made his legal representative. I produced the death certificate also.
Then,
The death certificate is at page number 79.
yes, mister, we'll send it back. You are the only contesting respondent.
Yes.
Respond number 10, yes.
But now, where the respondent, before deputy commissioner passing the order, where the respondent 5 to 10 had entered into a sale agreement with the purchaser. I had produced the sale agreement, page number 18.
No, now that matter has to go back to that DC, then you can take this thing.
Yes.
Yes, mister.
Yeah, yes, my lord.
You will set aside that DC order and will send it back.
Since
Even though it is in your favor,
Yes, yes, yes.
but thing is that it is against the dead person.
The order was passed against a dead person. Yes, my lord.
What do you say?
Since it is,
Otherwise also I want to grant interim order because you have invoked that provision after almost 22 years.
no, it was the responsibility of the petitioner to bring the LRs of the
No.
dead person on record.
That is true. On that aspect itself, order become void. Even if you says that order is in your favor, you are the legal representatives,
Yes.
He had to furnish the document before.
then the question is, even if I entertain that writ petition, they are entitled for the interim order on the ground that you have approached that AC after 20 years. On that ground, in view of the Supreme Court judgment, till that constitutional validity has to be challenged, then he is entitled.
But here they, without permission, without obtaining the sale permission, they have purchased the.
No, that is
land.
true. There is no doubt there is a violation of that provision of the
Violation,
act.
yes, yes.
The question is, Supreme Court said you have to invoke that provision within reasonable time.
These respondents, my lord, are illiterates and they don't have the worldly knowledge.
Even
And
then, that
henceforth-
Supreme Court said it should be reasonable. See, 2013, you have filed an application.
Yes, ma'am.
Act came into the force in 79,
78.
No, no, the
78,
reason was
79.
because of their innocence
80.
and illiteracy.
20, 33 years, 33 years delay. Can't be condoned. That is what that Supreme Court said. Following that, High Court also said in so many cases. Now the state has brought an amendment that is pending for consideration
Yes.
now.
The question of limitation does not arise.
Huh?
The question of limitation.
Two things. Now that whether you are agreed for going, send it back to that DC, or you want to argue on merit here, I will admit and grant stay for further proceeding.
The matter may be admitted and
Yes,
matter may be heard on merits.
yes. Government advocate is directed to take notice for respondent number 1 to 3. You are appearing for whom? Kevator.
Respondent
4
number
to
10.
10. All the family members.
Kevator is undertaken to appear for respondent number 4 to 10. Stay of annexure A and B. A na? Annexure A. Till next date of it. Yes.
Not to change the revenue entries. Now they had entered into a sale agreement.
Stay admele what they can do it,
Mr.
Mr.
Maintain state not to disturb
Yes.
having position of the status quo be maintained.
Yes, ಅದು ಹೇಳಿದ್ವಲ್ಲ. Yes, served in a copy. Yes.
Yeah,
If that order is stayed, they can't operate anything, mister. They are only, yes.
They will interfere with my position. That is the only.
On what basis?
Based on the sale agreement.
Sale agreement. Sale agreement is on the basis of the TSC order.
Yes.
DC
But
order.
before
That is
that-
stayed.
Before that.
See,
Before the deputy.
even
commissioner
after
passing
that
the-
order, Rule 5 says, proceedings has been initiated under section 39 of the Land Revenue Act. They have to take a position. Yes.
Hearing interlocutory application matter, serial number 47. Here Ravi Shankar for appellant, connected matter.
Appear for the appellant.
Shastri.
Yes.
ಸುಮ್ನೆ ರಜಾ ಆದ್ಮೇಲೆ ತಗೋಬಹುದು ಸ್ವಾಮಿ.
Subject no interest.
Yes.
After
Lieutenant
vacation.
of the TCR. Yes,
TCR
none of-
ಕಳ್ಸ್ಬೇಡಿ, ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡೋಣ.
Yes, leave this matter to 2 weeks.
After 2
Great, great.
Delay may be condoned without interest.
Sorry,
See, after 2 weeks, we'll see.
sorry, my lord, kindly pass over. Serial number 47. Kindly pass over, my lord.
Why? They want
Adralli
time.
memo not pressed, my lord.
Yeah, memo.
ಅದರಲ್ಲಿ ಮೆಮೊ ಫಾರ್ ರಿಟರ್ನ್ ಆಫ್ TCR ಅಂತ ಇಟ್ ಇಸ್ ನಾಟ್ ಪ್ರೆಸೆಂಟ್.
ಅದಕ್ಕೆ soon after vacation ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು.
ಆಯ್ತು.
Yes. Learned counsel for the appellant in MFA will condone the delay, Mr. Venkatesh.
Yes, my lord, without interest we will condone.
362 days delay in filing an appeal. Delay is condoned. Learned peruse that affidavit filed along with that application. For the reason stated in that accompanying affidavit, delay of 362 days in filing an appeal is condoned. IA 1 of 2019 is allowed, subject to condition. In case appellant succeeded in this appeal, he is not entitled for enhancement of compensation. He is not entitled for the interest for enhanced compensation amount for the period of 362 days. Learned counsel for the appellant submits that memo may be dismissed as not pressed. Yes. This matter after 2 weeks.
Great.
48, Sri Vidya GK for appellant, BH Sridhar.
For the appellant lords, there is delay of 59 days. Lords, BH Sridhar, our panel al gottida yarantane. I noted
BH Sridhar ಅಲ್ಲ ಅವ್ರು ಯಾರೋ ಬೇರೆ ಶ್ರೀಧರ್ ಅಂತ ಇರ್ಬೇಕು.
DS ಅಂತ ಹೇಳಿ ನಾನ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ, ಬಟ್ BH ಅಂತ ಹೇಳಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಆ ವಕಾಲತ್ ಹಾಕಿದಾರ ನೋಡ್ರಿ.
DS
ಇದರ
DS ಇದಾರೆ ನಮ್ಮ ಸೀನಿಯರ್ ಮಗ.
BH
ಇದೆ DS ಇದಾರೆ.
BH
ಗೊತ್ತಿಲ್ಲ.
ಏನಂತಿದೆ?
DS Sridhar ರಿಲಯನ್ಸ್ ಅಲ್ಲಿ ಇದಾರ.
BS ಮತ್ತೆ ಇಲ್ಲಿ ಅಂತ BH ಬರ್ತಿದೆ.
Lords, any other panel advocate may kindly be directed.
Wait madam. BS Sridhar ಇದಾರ?
DS ಇದಾರೆ.
ಅದು BH ಆಗಿದೆ ಅಷ್ಟೇ.
DS Sridhar panel ಅಲ್ಲಿ ಇದ್ದಂಗೆ.
Yes, BS.
I have no idea.
B for bat.
Please.
BS Sridhar is there, mister.
Yes, sir.
Then we'll direct it to show his name correctly in the cast item.
ತೋರಿಸಿದೆ ಅವ್ರ ಹೆಸರು.
BH ತೋರಿಸಿದೆ madam.
DS ಅಂತ ತೋರಿಸಿ.
DS ಅಂದ್ರೆ ನಮ್ಮ ಸೀನಿಯರ್ ಮಗ ಗೊತ್ತು ನನಗೆ.
BS, yes, he is in the panel.
Maybe I have no idea about it.
Then it's the problem. Because it is
I will telephone and inform him, madam.
yes.
ಸತ್ಯನಾರಾಯಣ ಶಾಸ್ತ್ರಿಗಳ ಮಗ.
Office. There is a delay of 59 days in filing appeal. IA 1 of 2018 is filed for condonation of delay.
Lords, if it is Mr. DS Sridhar, Milords, he's been attending, appearing for the claimants. ಅದಕ್ಕೆ that order may be recalled and any other panel advocate may kindly be directed, Milords.
Yes, Sridhar ಇಲ್ವಾ? Panel ಅಲ್ಲಿ ಇಲ್ವಾ?
ನನಗೆ
Claimants appear ಆಗ್ತಾ ಇದ್ದಾರೆ, but my knowledge is concerned. ಅದಕ್ಕೋಸ್ಕರ.
ಬೇರೆ ಕೊಡಿ ಯಾರು ಬೇರೆ ಕೊಡಿ.
No, but if he is there, why should I want to check?
I will inform him and find out whether he is there or not.
No, any other panel advocates are there, we can verify.
ರವಿ ಸಂಪತಿ ಇದ್ದಾರೆ.
ಅಲ್ಲ.
ವಿ ಪ್ರದೀಪ್ ಇದ್ದಾರೆ.
First, I want to confirm DS Sridhara.
It may be called on Monday, I will inform him.
DS Sridhar idaro illo anta ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೇ clarify. Otherwise let him, because there is a direction to take notice. ಅವ್ರು ತಗೊಂಡ್ಬಿಟ್ಟು ಪ್ರಿಪೇರ್ ಆಗಿದ್ರೆ I don't want to change the counsel.
Monday
ಅವ್ರಿಗೆ ನಾನು ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. I am directed to serve a copy because of the initials, Milords, even I am unable to. ಯಾಕೆಂದ್ರೆ BH ಅಂತ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ತದೆ.
ಯಾರು ಪ್ರದೀಪ್ ರವಿ ಸಂಪ್ರತಿ ಯಾರು ಇಲ್ವಾ?
ರವಿ ಸಂಪ್ರತಿ and ಪ್ರದೀಪ್ both are there.
No, I want to verify from them, not to give a notice. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ.
Your lordship may take it on Monday, I will inform him.
No, I don't want to for this purpose adjourning the matter. Unnecessary listing.
ಇವಾಗ ಫೋನ್ ಮಾಡ್ತೀನಿ.
ಅದಕ್ಕೋಸ್ಕರ
ಮಾಡ್ತೀನಿ. Your lordship may take it up in the afternoon.
Yes, pass over, let us see. ಯಾರು ಬರ್ಲಿ ಕೇಳೋಣ. Yes.
Number 49, Sripad V. Shastri for appellant, A.M. Venkatesh.
ಏನು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು R1ಗೆ.
Substituted service by way of paper publication. IA 1 of 2021 is filed for permission to take out notice to respondent number 1 by way of substituted service in Kannada daily newspaper, Vasa Digant, Bangalore edition. Peruse that affidavit for the reason stated in that accompanying affidavit. IA 1 of 2021 is allowed. Appellant is permitted to take out notice to respondent number 1 by way of substituted service in Kannada daily newspaper, Vasa Digant, Bangalore edition on or before
23rd October,
hearing date.
20th November.
Yes.
Serial number 50, Veena T.N. for appellant.
That's appearing for the appellants, my lords. Filed an IA for recalling order dated 22/10/2019. Was dismissed for non-compliance of office objections. Matter is related to seeking enhancement of compensation, my lords.
Have you completed that office objection?
Office objections complaint.
I three. Even the last dinner, you are not to seeing that what has happened to that case.
Lords.
Yes. IA 1 of 2023 is filed for condemnation of delay of 1,300 days in filing an application for recalling that order dated 22/10/2019. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 1,300 days in filing the application for recalling that order dated 22/10/2019 is condoned, subject to condition. In case appellant is succeed, the compensation is enhanced. He is not entitled for the interest for enhanced compensation amount for a period of 1,300 days. Consequently, IA 2 of 2023 is allowed. Order dated 22/10/2019 is recalled. The appeal is restored to the file. Issue emergent notice to respondent.
Serial number 51, O Mahesh for appellant.
I appear for the sought for substituted service to R4, my lord. Kindly be allowed.
Yes. IA 1 of 2024 is filed for permission to take out notice to respondent number 2 by way of substituted service through paper publication in Kannada daily newspaper Samyukta Karnataka of Bangalore edition for the reason stated in that accompanying affidavit. IA 1 of 2024 is allowed. Respondent number appellant is permitted to take out notice to respondent number 2 by way of substituted service through Kannada daily newspaper Samyukta Karnataka of Bangalore edition on or before
23rd October,
hearing date.
20th November.
Yes.
Serial number 52, R Shashidhara for appellant, K N Srinivasa.
Appear for appellant, my lord. Lower court records, it may be called.
Where is that? Srinivas. Office is directed to secure original records from the tribunal.
Serial number 53, Abhinav R for petitioner, connected matter, Subramanya R.
I appear for the petitioner. First matter, my lord, notice has to go. LR application.
IA for condemnation of delay, bringing LRs of
Yes,
whom?
my lord.
R4.
R4, notice has to go to the LRs.
Notice agilva?
No, agila, sir.
Yes, issue notice on IA 1, 2 and 3 of 2023 for LRs of R4.
Emergent notice.
Emergent notice.
Yes.
Yes.
In connected matter, my lords, process fee is to be paid.
You have to pay that process.
Yes, my lords. Once, my lords, the notice has been ordered. Thereafter, my lords, R4, A, B and E and F, my lords, are served.
C and D.
C and D.
Yes. Week's time is granted to pay the process, issue notice to R4, C and D. Ado in the connected matter. First matter ali notice on IA. Yes.
Serial number 54 adjourned, final hearing matter. Serial number 55, Kailash Shankar PS for appellant, A N Krishnaswamy, H.M. Banu.
That's last time. The case of death, my lord.
Kodi. What is the dispute?
The only income dependency and consortium material purpose.
Dependency ಏನು ಯಾರು?
Dependency with the parents of the deceased. Parents and brother of the deceased.
Tribunal
Bachelor.
Death is bachelor. 50% ಮಾಡಿದಾರಾ?
40% future prospects ತಗೊಂಡಿದ್ದಾರೆ, 50% deduction ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ
Usually we have proved income.
what is that income?
As 20,000 per month, my lord.
Working as
a delivery executive in Instacart Services Private Limited.
criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Criminal 15,000 average income ತಗೊಂಡಿದ್ದಾರೆ for 6 months. Kindly peruse the para number 38 of the page number 28, my lord. ಅದು ಮೊನ್ನೆ ಸೋಮವಾರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೆ. ಏನಕ್ಕೆ ಅವ್ರು ಬರ್ಲಿ ಅಂತ.
ಪ್ಯಾರಾಗ್ರಾಫ್
38, my lord. Page number 28. With regard to the income of Inga is concerned, it is the evidence of PW that he was getting 20,000 per month by working as a delivery executive. It is the evidence of PW3 that measures Instacart Services Limited has made payment of rupees 1,19,972.94 towards services fee disbursement on perusal of Exhibit P15 bank statement of the deceased and also Exhibit P29 payment details of the deceased submitted by HR executive. Instacart reveals that he was receiving weekly payment.
Yes, 3 months average ತೆಗೆದ್ರೆ.
Please.
Pass on. Afternoon, if he is not come, I will dispose of.
Please.
Number 56, Ravish Bendy for appellant, connected matter, N.R. Rangegowda.
Yes, Mr. Rangegowda, what is this?
Lord, their appeal is, my lord, deceased was not holding valid and effective driving license as of the date of accident.
Only one, that is
One
brought.
contention, then my lord, 1/3 has been deducted instead of 50%. Claimed by my lord, wife and husband and 2 minor children.
No, first is that on liability.
Liability.
Why?
Lord, paragraph 16 of the judgment, my lord.
Yes.
May I read, my lord?
Yes.
While discussing the above, I have already come to the conclusion that accident has occurred due to rash and negligent riding of Honda Activa by its rider. When the accident occurred due to rash and negligent riding of Honda Activa by its rider, which belongs to respondent number 1 and 2, it is its insurer. But in the present case, it is the contention of the respondent number 2, the deceased not holding valid and effective driving license at the time of accident. Hence, second respondent examined RTO Yelahanka as RW1 and he got marked 2 documents, that is Exhibit R1 authorization letter and Exhibit R2 learner's license. RW1 deposed that the deceased having learner's license as per Exhibit R1 to drive car and there is no indication with regard to the LLR to drive the 2-wheeler. But in the present case, the police have filed the charge sheet against the rider of Honda Activa and the said rider having DL as on the date of accident. And policy for the said vehicle is in force. Learned counsel for the petitioner relied on citation reported in 2008 AR SCW 3981 Sudhir Kumar Rana versus Surinder Singh and others, wherein lordship held that Motor Vehicle Act 59 of 1988 under section 168 accident claim for compensation negligence, person having vehicle without license, same by itself may not lead to finding of the negligence as regards accident. No finding of fact arrived at that claimant was driving a 2-wheeler rashly and negligently when met with an accident with mini truck, thus only because he was not having a license, he could not be held to be guilty of contributory negligence.
At the tribunal has held only
my lord,
Honda
Activa is responsible for the accident.
That accident, she was not wearing that helmet, and since the contrary to that rule, so helmet ಹಾಕೊಂಡಿರ್ಲಿಲ್ಲ.
Please.
He has not produced any document about the age. It is submitted that the husband of the deceased Rajeshwar is not dependent of the income. Rajeshwar was earning 2,000. DL ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ರಿ? Respondent one admitted.
Turner's license ಇತ್ತು ಅಂತ.
Cross examination will be proved stand in the name of the deceased. Elsewhere. With the GST certificate. Given to the first respondent attribute to LLR, she was authorized to motor vehicles without gear. At the time of the accident, his wife alone riding the motorcycle, nobody was, and she was violated that, yes. Idiana, she was not wearing helmet.
Helmet, my lord, according to the division bench decision, my lord, is a panel provision. My lord, kindly pass on that judgment, my lord.
Yes, what is that, this thing?
Lord, date of accident, my lord, 13/8/2017.
2017.
Age of the deceased, my lord, 36 years.
Yes.
My lord, claim by my lord husband and two minor children. Lord, tribunal, my lord, after considering the evidence, my lord, taken notional income 8,500 per month. Added, my lord, 40%.
Claim ಮಾಡಿದ್ರಿ?
My lord, you claim 25,000 per month.
$2017,
Please.
7,000.
Added, my lord, 40% income of the deceased towards future prospects. 1/3 has been deducted.
1/3 ಯಾಕೆ?
Lord, in case of a married person, my lord.
No, he is a bachelor.
Allah, married.
Who are the claimants?
Claimants, my lord, husband and the two minor children.
Then,
Wife is the.
No, then they have taken a contention that, no?
50% ಆಗ್ಬೇಕು ಅಂತ ಅವ್ರ ಕಂಟೆಂಟ್.
ಎಲ್ಲಿದೆ?
In case of Saralavarma, my lord, 1/3 has been deducted.
Ground 30.
That is right.
Respondent husband deceased cards, ration card, therefore the petitioner is not dependent upon the income of the deceased. Who are the claimant number 2?
The sons.
Sons.
Minor sons.
ಮಕ್ಕಳಿದಾರಲ್ಲ. 1/3 is correct.
ಹೌದು. At the time of accident, my lord, they are minors. Then, my lord, convention it's only 70,000 has been granted.
Yes, interest.
Interest awarded, my lord,
6%.
6%.
That's all. Where is Binny? ಬಂದಿದಾರಾ?
Morning idru.
Yes, third. Yes. So and so, learned counsel appearing for insurance company has contended that at the time of the accident, deceased was not wearing helmet and also not holding DL, not holding driving license to drive two-wheeler. she has violated Rule 3 of Central Motor Vehicles Rules. Hence, she has also contributed to that extent. Tribunal has error in held that rider of Honda Activa bearing registration number KA04 GA 8207 alone is negligent in causing that accident. In respect of quantum, he has contended that even though claimant has claimed that deceased was earning 25,000 per month, they have not produced any document to establish the same. Therefore, notional income assessed by the tribunal 8,500 per month is on higher side. Secondly, he has contended that the claimants are not depending upon that income of the deceased. Tribunal, instead of deducting 50% of the income of the deceased for personal expenses, as error in deducting only 1/3. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is on higher side, sought for allowing that appeal filed by insurance company by dismissing appeal filed by the claimant. Nimdu idya? Please. Serial number estiда?
Not 56.
56.
2056 of,
Yes.
2069 of 19 climate sir.
So and so learned counsel appearing for the claimant has contended that the accident is occurred due to the negligence of rider of Honda Activa. Tribunal has rightly held that rider of Honda Activa alone is negligent in causing that accident. Full stop. He contended that, he submitted that non-wearing helmet or not holding any driving license, it's an offense under Motor Vehicles Act. Unless it is proved that deceased has contributed to the accident, it cannot be held that deceased also negligent to cause an accident. In respect of quantum, he has contended that at the time of the accident, deceased was earning 25,000 per month. Tribunal has assessed notional income of the deceased was 8,500 per month is on lower side. Secondly, he has contended that the claimants are husband and minor son of the deceased. They are entirely depending upon the income of the deceased. Therefore, tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. Lastly, he has contended that future prospects ಕೊಟ್ಟಿದ್ದಾರಾ?
Please.
In view of judgment of apex court in case of Magma, claimants are entitled 40,000 each. Hence he sought for enhancement of compensation. Heard the learned counsel for the parties. Peruse judgment and award. Original records. Yes, original records. It is not in dispute. What is the name of the deceased, Mr.?
Name of the deceased, my lord.
Appellant, file mistakes ಆಗಿದ್ರು. ತಗೊಂಡು kindly pass it over.
ನಿಮ್ದು ಎರಡೇ ಗ್ರೌಂಡ್ ನೋಡಿದ್ದು. ಒಂದು ಹೆಲ್ಮೆಟ್ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಅವರು ಡಿಪೋಷನ್ ಅಲ್ಲಿ she admitted that husband of that petitioner, deceased husband, ಅವರು only 50% of income ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Kindly pass it over.
ಆಯ್ತು, ನಿಮ್ದು ಗ್ರೌಂಡ್ ಇಷ್ಟೇ. ಹೆಲ್ಮೆಟ್ ಹಾಕಿಲ್ಲ, DL ಇಲ್ಲ. ಕ್ವಾಂಟಮ್ ಅಲ್ಲಿ 1/3 ಅಲ್ಲ 50 ಮಾಡ್ಬೇಕು ಅಂತ.
50 ಮಾಡೋದು ಇನ್ನೊಂದ್ ಸರ್.
ಮೈನರ್ ಚಿಲ್ಡ್ರನ್ ಇದಾರೆ, ಹಸ್ಬೆಂಡ್ ಬಿಡಿ.
ಅಲ್ಲ, ಅವ್ರ ಮೊಮ್ಮಕ್ಕಳು ಸರ್ ಅವರು.
ಮೊಮ್ಮಕ್ಕಳಲ್ಲ, ಮಕ್ಕಳು.
Kindly pass it over.
They are Rajana's sons. Rajana is the husband of the deceased.
ಅದ ಇದರಲ್ಲಿ ರೇಷನ್ ಕಾರ್ಡ್ ಮೊಮ್ಮಕ್ಕಳು ಅಂತ ಐತ್ರಿ ಅದು. ನಾನು kindly pass it over.
ಮೊಮ್ಮಕ್ಕಳು ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬರ್ತದೆ? ಇಲ್ಲಿ ಸನ್ ಆಫ್ ರಾಜಣ್ಣ ಅಂತ ಇತ್ತಲ್ಲ, 17 ವರ್ಷ.
ಅದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ. Kindly pass.
I have completed dictation. You just see and make it submission. If there is even then also 1/3 is entitled, she is married, but you verify whether they are son or not. But you see that caste title.
ಕಾಸ್ಟ್ ಇಲ್ಲಿ ನೋಡ್ತಾರೆ, ಫೈಲ್ ಇಲ್ಲ. ಕೈಂಡ್ಲಿ ಅದು ಇನ್ಕಮ್ದು ಸರ್.
Income, notional income.
ಅದರಲ್ಲಿ 50% is only entitled. ಅವ್ರು is getting he said that he is only loss of the 50% ಅಷ್ಟೇ ಲಾಸ್ ಆಗಿರೋದು ಅಂತ ಹೇಳಿದ್ರು. If remaining he is getting the 50% of income. Deposition ಅಲ್ಲಿ he is admitted in my cross examination.
ಏನಂತ?
I have lost ಫೈಲ್ ಇಲ್ಲ. ಕೈಂಡ್ಲಿ 230 ನಿಂತಿದ್ದು ಯಾರು ತಗೊಂಡಿರೋ ಗೊತ್ತಿಲ್ಲ. ಕೈಂಡ್ಲಿ ನಾನು ಟೆಸ್ಟ್ ದ ಫೈಲ್ ಅಂಡ್ ಸಬ್ಮಿಟ್.
No, I have completed dictation. I can't give dictation to other this thing. Therefore, I am
Deposition of PW1P. Cross examination is admitted that I am 50% ಅಷ್ಟೇ ಇನ್ಕಮ್ ಬರ್ತಾ ಇದೆ ನನಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ತೊಂದರೆ ಇಲ್ಲ.
He is entitled only 50% of income.
Notional income may be considered, my lord. ನಾವ್ ಹೇಳಿರೋದು ಅರ್ನಿಂಗ್ 25,000.
ನೋಷನಲ್ ಇನ್ಕಮ್ ಅಲ್ಲೂ 50% ಏನೆ.
ನೋಷನಲ್ ಇನ್ಕಮ್ ಅಲ್ಲ, ಭಾಗಿಯಾಗಿದೆ ಅಂತ ಸರಿಯಲ್ಲ. ಶವಪಟ್ಟಿಗೆ ಸೋಣಿಸೋ ನನ್ನ ಹೆಂಡತಿ ಪ್ರತಿ ತಿಂಗಳು 25 ಸಂಪಾದನೆ ಮಾಡುತ್ತಿದ್ದಳು ಎಂದು ತೋರಿಸಲು ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ತೋರಿಸಿ ಸರಿಯಾದ ಹೋಟೆಲ್ ತೋರಿಸಿ ಸರಿ. ನನ್ನ ಹೆಂಡತಿ ಹೋಟೆಲ್ ನಡೆಸುತ್ತಿದ್ದು, ನಾನು ಅಸಿಸ್ಟ್ ಮಾಡ್ತಿದ್ದೆ. ಈಗ ನನ್ನ ಮಕ್ಕಳು ಹೋಟೆಲ್ ಅನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುತ್ತೇವೆ. ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ನಲ್ಲಿ ಸೋಣಿಸೋ ನನ್ನ ಹೆಂಡತಿ ಗಾಡಿ ಓಡಿಸುವಾಗ ಅವಳಿಗೆ DL ಇಲ್ಲ ಸೋಣಿಸೋ ಮಾಡ್ತಿದ್ದಾರೆ. ಹೋಟೆಲ್ ನಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಹಾಜರುಪಡಿಸಿರುತ್ತವೆ, ಸರಿಯಲ್ಲ. 2,000 ಶವ ಪರಿಚಯ. ನನ್ನ ಮಕ್ಕಳು ಹೆಂಡತಿ ದುಡಿಮೆ ಮೇಲೆ ಅವಲಂಬಿತವಾಗಿರ್ಲಿಲ್ಲ, ನಾನೇ ಹೋಟೆಲ್ ನಡೆಸ್ತಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಸ್ಥಳ ಪಂಚಮಿ ನೋಡಿದ್ರೆ ನನ್ನ ಮಕ್ಕಳು ನನ್ನ ಹೆಂಡತಿಯ ದುಡಿಮೆ ಮೇಲೆ ಅವಲಂಬಿತರಾಗಿರಲಿಲ್ಲ, ನಾವೇ ಹೋಟೆಲ್ ನಡೆಸುತ್ತಿದ್ದರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಯು ಸಿ ದಟ್.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ಓನ್ಲಿ 50% ಅಷ್ಟೇ ಲಾಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯು ರೀಡ್ ಎಂಟೈರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ನಾವು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ, ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಒಂದ್ 10-15 ನಿಮಿಷ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತಾರೆ ಫೈಲ್.
ಅಲ್ಲ, ರೀಡ್ ಒಂದೇ ಪ್ಯಾರಾ ಇರೋದಲ್ಲ, ಅದೇ ತಾನೆ PW1.
ಇಲ್ಲ, ಲಾಸ್ಟ್ 3 ಲೈನ್ ಪ್ಲೀಸ್ ನೋಟ್. ಅಷ್ಟೊಂದು ವರಮಾನ ಬರುತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಎಂದು ನುಡಿದಿದ್ದಾರೆ. ಈಗ ಅರ್ಧ ವರಮಾನ ಬರುತ್ತಿದೆ ಎಂದು ತೋರಿಸಲು ಅದು ಇದೆಯಲ್ಲ, ಅರ್ಧ ವರಮಾನ ಬರ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು.
ಎಲ್ಲ ಇರ್ತಾರೆ,
ಹೇಳ್ತೀವಿ.
Even children are there, mister. Even that.
The children are depending on the father, not on the income of the.
It is depending upon that mother. She is running that canteen.
But she is not running. There is.
That is what that
18, 19, 20, 22. They all stands in the name of the
yes.
Rajanna.
Yes.
50% ಅಷ್ಟೇ ಇನ್ಕಮ್ ಲಾಸ್ ಆಗಿದೆ ನನಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Consider, Mr. Yes.
ಒಂದು 5 minutes ಪ್ಲೀಸ್. ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ಕಿನಲ್ಲಿ ತೋರಿಸಿದಷ್ಟು ವರಮಾನ ಈಗಲೂ ಬರುತ್ತಿದೆ ಅಂತ ಸಾಕ್ಷಿ ಹೇಳಿದ್ರೆ ಅಷ್ಟೊಂದು ಈಗ ಬರುತ್ತಿಲ್ಲ, ಅದರಲ್ಲಿ ಅರ್ಧ ಬರುತ್ತಿದೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. He is admitted in my cross examination, last 3 lines. Because he is getting because of loss of that his wife, he is getting the 50% income, not entire income.
ಹೋಟೆಲ್ ಈಗಲೂ ಕೂಡ ಮುಂದುವರಿಸಿದ್ದೇವೆ ಅಂದ್ರೆ ಸರಿ. ನನ್ನ ಹೆಂಡತಿ ಹೋಟೆಲ್ ನಡೆಸುತ್ತಿದ್ದಳು, ನಾನು ಅಸಿಸ್ಟ್ ಮಾಡುತ್ತಿದ್ದೆ. ಈಗ ನಾನು ನನ್ನ ಮಕ್ಕಳ ಹೋಟೆಲ್ ಅನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೇವೆ. ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ಸ್ ಅಲ್ಲಿ ತೋರಿಸಿದಷ್ಟೇ ವರಮಾನ ಈಗಲೂ ಬರುತ್ತಿದೆ ಎಂದರೆ ಸಾಕ್ಷಿ
ಅರ್ಧ ವರಮಾನ,
ಅಷ್ಟೊಂದು ವರಮಾನ ಬರುತ್ತಿಲ್ಲ, ಅದರಲ್ಲಿ ಅರ್ಧ ಬರುತ್ತಿದೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಈಗ ಅರ್ಧ ವರಮಾನ ಬರುತ್ತಿದೆ ಎಂದು ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲಾತಿ ಕೊಡಿಸಿರುವುದಿಲ್ಲ.
Therefore, there enter only 50% loss of income of the death of his wife.
That cannot, I will consider. Yes.
ಅಲ್ಲ, ಅರ್ಧ ಇನ್ಕಮ್ ಬರ್ತಾ ಇದೆ.
Our contention ಅಲ್ಲಿ, he said they are not entitled for tribunal as error in deducting 1/3 instead of 50 ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರದು ಕಂಟೆನ್ಷನ್ ಅಲ್ಲಿ. He contended that in the cross examination, PW1 has admitted that he was getting income of 50% from the hotel business. See, wife is not restricted to hotel, mister. Our service is given to the children.
Definitely, please. My submission, humble submission is that
record ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
That is to be considered by this honorable court because he is loss of only 50% of income.
Now your contention is considered. I will answer that. Yes. ಎಲ್ಲಿಗೆ ಬಿಟ್ರಿ ಈಗ? Asked. Yes. There is that judgment and award and original records. Even though claimant has claimed that deceased was earning 25,000 per month, they have not produced any document to establish the same. Therefore, notional income must be assessed as per the guideline for the accident occurred in 2017, 11,000 rupees. 50% ತಗೊಂಡ್ಲಾ?
50% ತೊಳಿ ಪ್ಲೀಸ್.
ಅಲ್ಲ, 50% ಅಂದ್ರೆ 50%.
25% ಇಲ್ಲ, ಅದು ನೋಸ್ಟ್ಲಿ ಇನ್ಕಮ್ ಗೆ
25,000
ಅವ್ರು 25,000 ರೂಪಾಯಿ ಹಾಕಿದ್ರು ಅಂತ ಡೆಫಿನೆಟ್ಲಿ ಮೈ ಅಪೀಲ್ ಟು ಬಿ ಡಿಸ್ಮಿಸ್ ಪ್ಲೀಸ್. ನಾಟ್
yes.
ನಾವು ಇಲ್ಲಿ they have not proved their income.
I will answer you. You just listen. Therefore, notional income has to be assessed 11,000 per month. The claimants are husband and minor children. The specific case of that claimants that they are entirely depending upon income of the deceased. PW1 in his evidence, he has categorically stated that deceased was running a hotel business. The claimants are assisting her and getting monthly income of rupees 25,000.
One small submission, please. ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಿದಾವೆ ಹೇಳಿದಾರೆ ಸರ್, ಇವ್ರ ಹೆಸರು ಇಲ್ಲ, ಡಿಸೀಸ್ಡ್ ಹೆಸರು ಇಲ್ಲ. ಇವನ್ ಸಾಹೇಬ್ರು ಏನ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಆಫ್ಟರ್ ಹರ್ ಡೆತ್ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ದಿ ರಾಜಣ್ಣ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ತರನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
ಅವ್ರ ಅವ್ರದ್ದು ಸಬ್ಮಿಷನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. 25,000 per month after the death of the wife of the first petitioner. In the cross examination, he has admitted that he is getting 50,000, 50% of that income from the hotel business. The claimants number 2 and 3 are the minor children. They are depending upon the income of the deceased. Considering that evidence of the parties, material available on record, I am of the opinion that tribunal is justified in deducting 1/3 of the income of the deceased for personal expenses. Tribunal has rightly added 40% of the income of the deceased for future prospects. The multiplier applicable to that age group is 36. Accordingly, loss of dependency has been reassessed as follows.
11,000 plus 4,400 at the rate of 40%, 15,400 minus 5,133 at the rate of 1/3, 10,267. 10,267 into 12 into 15, 18,48,080.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. If apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. 2 and 3 is entitled 40,000 each for parental consortium. In respect of contention of the counsel for the DL, insurance companies regarding deceased was not wearing that helmet. Not wearing that helmet and not having any DL to ride the two-wheeler. Tribunal has given a specific finding that accident is occurred due to the negligence of driver of the offending vehicle Honda Activa bearing registration number KA 04GA 8207. The apex court in 2008 12 SCC 436 has held that if a person drives a vehicle without a license, he committed an offense. The same by itself may not lead to a finding of negligence as regarding the accident. Para 9 extract. The relevant paragraph 9 is extracted below. Helmet. Even non-wearing of the helmet is also offense under Motor Vehicles Act. Unless it is proved that the deceased has contributed to the extent. Therefore, tribunal has rightly held that rider of Honda Activa bearing registration number KA 05 GA 8207 is only the negligent in causing that accident. Accordingly, interest is there 6%. The appeal is allowed in part. Appeal filed by the claimant is allowed in part. appeal filed by the insurance company is dismissed.
One submission, please.
Hmm.
They are entitled only 50% of total income granted by the Sambal court. Because he is admitted he is getting the 50% of income.
No, I have answered your question. Only remedy for you to challenge. I can't write a judgment what you said. I have heard you, then I have
Well,
come to the
I
conclusion.
can understand. That is the admission given by the.
But your submission has been recorded, then I have given a finding. It is not that what you have argued, I have to pass.
No, Hangal sir.
ನಿಮ್ಮ ಎದುರಿಗೆ ನಾವು hear
No. Judgment ಬಗ್ಗೆ I am not they are entitled only 50% loss. The loss of the petitioner only 50%. Therefore, kindly consider the 50% of income in the total income of the granted by this honorable court. My humble submission.
That cannot be. Yes. Yes. See, you are restricting that deceased is only for that this thing. Women's has to be considered. You see that Supreme Court, how that she is helpful for that has an even for an housewife. Why they have to be given a
Lord, one more judgment is there. The service rendered by the mother and wife cannot be considered by way of value, cannot value the money.
Now you are saying that since in the hotel business she is getting only 50, entire business, you are restricting her only for the hotel business, not taking care of that minor children. Yes. Amount in deposit is transferred to criminal. Yes. There is a delay of 59 days in filing appeal. IA-1 of 2019 is filed for condonation of delay. Peruse that affidavit for the reason stated in that accompanying affidavit, delay is controlled.
Cell number
Yes.
57, Syed Akbar Pasha for appellant, Manjula and Tejas.
You are ready, your lordship.
The appeal for appellant.
Yes.
Case of injury, my lord.
Yes.
Para 14 is not the injury.
Yes.
The last three line in the para 14, the doctor has opined that there is a 28% disability with respect to right lower limb. There is 18% disability in respect of left lower limb and 23% disability in respect of right wrist. But wholesome limb to the whole body, 23% is being considered.
Yes, where is that finding?
Para
Criminal
14,
ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಇವರು?
28% to the right lower limb, 18% to the left lower limb, and 23% to the right wrist. The tribunal not taken 23% to the whole body.
What is doctor evidence? Opinion that the 28% functional disability with respect to the right lower limb, 18% disability left lower limb, 23 disability in respect of right wrist.
ಅದೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ 69% ಆಗುತ್ತೆ. ಅದಕ್ಕೆ 1/3 to the whole body ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, 23%.
Then it's correct. Yes.
Notional income.
Income has to be enhanced, your lordship.
11,000.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್?
9,000 ತಗೊಂಡಿದ್ದಾರೆ. 11,000 ತಗೋಬೇಕು. As per the chart.
Yes. ನೀವ್ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ?
Not we sought for 40,000.
20,000. How many days was it?
47 days not inpatient ಇದೆ.
46 days.
47 days.
46 days.
Yes, your lordship. ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರು ಅವರು.
What are the injuries?
ಮೇ ಐ, your lordship?
Yes, yes.
ಒಂದ್ ಅಬ್ರೇಷನ್ ಇದೆ, ಆಮೇಲೆ ನಾನ್ ಫ್ರಾಕ್ಚರ್ ಇದೆ ಸ್ವಾಮಿ. ಇಂಜುರಿ ನಂಬರ್ 1 is simple in nature and second, third 2 to 5 are grievous in nature ಅಂತ ಹೇಳ್ತಾರೆ. Tribunal has awarded 80,000 rupees towards that, your lordship. Medical expenses as it is 42,000 because he has taken treatment in the government hospital. ಆಮೇಲೆ
amenities one ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ, amenities ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
What is that interest awarded?
9% ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Yes, mister. That's all.
11,000 ತಗೊಂಡು.
Yes. That's all. Tali. So and so learned counsel appearing.
Laid up period allu 11,000 ತಗೊಂಡು.
Yes. Counsel for the claimant has contended that at the time of the accident, he was earning 40,000 per month doing milk vending business.
Agriculture and milk vending.
Agriculture and milk vending business. Tribunal has considered notional income of the claimant as 9,000 per month is on lower side. Secondly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 46 days. He has suffered lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of immunities, pain and suffering, other incidental expenses is on lower side. Tribunal has not granted any compensation for loss of immunities. Hence, sought for enhancement of compensation. Per contra, Shri so and so learned counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 40,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 9,000 per month. She further contended that considering that evidence of doctor and injury suffered by the claimant and considering that medical records, the overall compensation awarded by the tribunal just and reasonable, not for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award and original records. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 20th/8/2017 due to rash and negligent driving of driver of car bearing registration number AA04 ML 2128. Due to the accident, claimant has suffered the following injury. Para 13 is the injury, extract matter. Considering that injury suffered by the claimant and medical records and evidence of the doctor, tribunal has rightly assessed whole body disabilities 23%. Even though claimant has claimed that he was earning 40,000 per month, he has not produced any document to establish the same. Under that circumstances, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority for the year of accident occurred in 2014. Notional income has to be considered as
11,000.
17, some 2017, you're not sure.
17 actually.
11,000.
Yes, 2000. For the year of 2017, notional income has to be considered as 11,000. The multiplier applicable to the TH group is 15. Accordingly, loss of income due to the disability has been reassessed as follows.
11,000 into 12 into 15 into 23%, 4,55,400.
Due to the accident, claimant has suffered the following injury. He was inpatient for a period of 46 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation. The claimant is entitled for loss of income during the later period for 4 months. The claimant is also entitled for loss of immunities, 40,000. Other head, compensation awarded by the tribunal is just and reasonable. Accordingly, the enhanced compensation amount carries 6% interest. Accordingly, appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes.
Serial number 58 adjourned. Serial number 59, Rajshekar as for appellant, connected matter G1K. Serial number 59.
Waiting for appellants, my lord. Kindly TCR may be called, my lord.
TCR bandide. It's in that hearing. Yes, what is that you are challenging?
Connected.
You are challenging on what ground, mister? You are for enhancement.
I am for enhancement.
Then you are challenging on what?
Liability, my lord. That the same has been not been considered in this judgment, my lord.
No, FIR register against whom?
Driver of the KSRTC driver.
but-
Charge sheet also filed against KSRTC driver, my lord. But in the criminal case, my lord, in the examination, the petition has stated that, my lord, while talking the phone, he has while driving the bus and he had the bus on the backside.
Negligence has been, you have been convicted, then what is that, this thing in that? That is the only ground.
That's the only ground, my lord. That submission may be taken, my lord.
Huh?
That submission may be taken, my lord. That's the only ground, my lord.
Where
The
is
charge
that?
sheet and FIR all are against the driver of the KSRTC driver.
Tribunal has not considered that exhibit R1 in the proper perspective. R1 is the judgment passed in criminal case register and driver of the bus. The petitioner, well as a pillion writer, have turned hostile.
There is some contributor negligence. 100% liability is fixed on the driver.
Yes, clearly established the fact that there is no harsh and even playing the part of the driver of the bus. Tribunal is not justifying. Tribunal expect to upset the evidence of the petitioner by taking over the microphone. Tribunal has not justified denying the contention of the driver of the bus that petitioner is negligent. ನಿಮ್ದು ಕಂಟೆನ್ಷನ್ ಅವರು ಮೊಬೈಲ್ ಅಲ್ಲಿ ಮಾತಾಡ್ತಿದ್ರು ಅಂತ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಏನು ಫೈಂಡಿಂಗ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಅವರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಹಾಸ್ಟೆಲ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯುವರ್ ಸೇಯಿಂಗ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇಸ್ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಟ್ ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್. ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಸಮ್ಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. Yes. What is your
Really, actually, he is a senior mechanic. Earlier, he was worked in different countries, my lord. And later, he started a mechanic workshop here itself, Somapete. And actually, the disability, the doctors assessed.
For riding his friends who was proceeding in that Suzuki.
Yeah, Suzuki. So, ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ಇದರ ಪ್ರಕಾರ 90% ಅಂದ್ರೆ ರೈಟ್ ಹ್ಯಾಂಡ್ ಫುಲ್ ಆಕ್ಚುಲಿ ಆಂಪಿಟೇಷನ್ ಇದೇ ಮಾಡ್ಬೇಕಂತ ಎವಿಡೆನ್ಸ್ ಇದೆ ಡಾಕ್ಟರ್. ಸೊ 90% ದಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಲಿಂಬು ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಬಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಸೆಸ್ ಟೇಕನ್ ಕನ್ಸಿಡರೇಷನ್ 30%, 1/3 ಆಫ್ ದಟ್
ಏನಾಗಿದೆ,
ಕೈ ರೈಟ್
ಆಗಿದೆಯಾ?
ಆಂಪಿಟೇಷನ್ ಹೌದು, ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ ಆಂಪಿಟೇಷನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರು ಏನೋ ಅದನ್ನ ಯೂಸ್ ಮಾಡೋಕೆ ಆಗಲ್ಲ ಅಂತ ಬಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಡಾಕ್ಟರ್.
ಯು ಆರ್ ರೆಡಿ ಮಿಸ್ಟರ್ ಆನ್ ದ ಕ್ವಾಂಟಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್?
ಎಸ್ ಮೇಡಮ್.
Yes. Where is that evidence of the doctor?
Doctor evidence, PW 2.
ಟ್ರಿಬ್ಯುನಲ್ ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ?
30% ತಗೊಂಡು, ಯಾಕಂದ್ರೆ 90% ಪರ್ಟಿಕ್ಯುಲರ್ ಲಿಂಬುಗ್ ಅಂತ ಕೊಟ್ಟಿದ್ದನ್ನ 1/3 ತಗೊಂಡು 30% ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ
ವೇರ್ ಇಸ್ ದಟ್ ಡಿಸ್ಕಷನ್? You read para 27. 28.
The petitioner contended that he was working as a heavy vehicle mechanic, and because of injuries sustained to the right hand, he was not able to carry out the work of mechanic as he has done prior to accident. So totally he is disabled from doing any work. With respect to this respect, the petitioner examined the doctor through the court commissioner. Dr. PW2 deposed that because of the injuries sustained by the petitioner, he is having a disability to the extent of 90% to the right upper limb. So when it is taken into consideration to the whole body, the disability would be 1/3 of the particular limb. Hence, for the whole body, the disability would be 30%. So the petitioner is aged about it. So
ಏನ್ ಆಂಪಿಟೇಷನ್ ಏನೂ ಆಗಿಲ್ಲ. ವಾಟ್ ಇಸ್ ದಟ್ ಇಂಜುರಿ?
Injury ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ PW2 ಎವಿಡೆನ್ಸ್ ಸೆಕೆಂಡ್ ಪೇಜ್ ಮೇಲೆ
Injury sustained and fracture of right radial, fracture of plus.
Para 3 of the doctor evidence, chief examination.
That in our hospital, right radial artery. ಬರೀ ಫ್ರಾಕ್ಚರ್ ಅಷ್ಟೇ ರೀ ಏನಾಗಿದೆ
But ಅಲ್ಲಿ
only
chief
fracture.
Doctor chief examination para 3 ಅಲ್ಲಿ the patient
Doctor has not see has given that each component's disability.
ಅದು ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್ 90%? He has straight away said 90%.
90% ಅಂತ ಹೇಳ್ದ. But ಅಲ್ಲಿ
He has to give that each components how it is affected, what is the degree of disability and all. Nothing is there. You see that one page or 90% and around 100% ಅಂತಾನೆ ಹೇಳ್ಬಿಡ್ಬೋದಿತ್ತಲ್ಲ.
ಹೌದು. But
Say 90%. There should be some explanation.
ಅಲ್ಲಿ
Nothing is there, Mr.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಬಲ ತೋಲಿನಿಂದ ಕೆಳಗೆ ಯಾವುದೇ ಫಂಕ್ಷನ್ ಇರುವುದಿಲ್ಲ.
90% ಫಸ್ಟ್ ಅಸೆಸ್ ಮಾಡಿರೋದು ಹೆಂಗೆ? ಕೈಗೆ ಇಂಜುರಿ ಆಗಿದೆ, ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ. 90% ಹೆಂಗ್ ಬರುತ್ತೆ ಅದು?
ಮತ್ತೆ ಅಲ್ಲಿ ಅದೇ ಆರ್ಟಿಫಿಷಿಯಲ್ ಇದನ್ನೇ ಹಾಕ್ಬೇಕಾಗತ್ತೆ, ಅದಕ್ಕೆ ಒಂದು 5 lakhs ಮೇಲೆ ಆಗತ್ತೆ ಅಂತ ಒಂದು ಇನ್ನೊಬ್ರು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಕೊಟ್ಟಿಲ್ಲ.
That is not part of that record.
PW.
Photo, have you produced the photograph?
Photograph mostly produce but para 26 of the judgment regarding the 26 ಅಲ್ಲ ಸರ್. 31. ಅದಲ್ಲಿ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಟಿಫಿಷಿಯಲ್ ಲಿಂಬಿಗೆ ಸುಮಾರು 5,40,000 ಆಗತ್ತೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ವೇರ್ ಇಸ್ ದಟ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಏನಾರು ಇದೆಯಾ?
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ತಿಲ್ಲಲ್ಲ, ಡಾಕ್ಟ್ರು ಏನು ಹೇಳಿಲ್ಲ.
Yes, sir.
Nothing is there. If there is a photograph, at least we can see. ಏನು ಕ್ರಶ್ ಇಂಜುರಿ
ಫೋಟೋಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ 166.
That is what that ಒಂದು ಇದ್ ಮುರಿದೋಗಿದೆ, ದೆನ್ ಸ್ಕಿನ್ ಕ್ರಾಫ್ಟಿಂಗ್ ಆಗ್ಬಾರ್ದು ನಥಿಂಗ್, ಕಂಪ್ಲೀಟ್ ಸ್ಕಿನ್ ಕಿತ್ತೋಗಿದೆ ಅಷ್ಟೇ. Nothing has been.
Some amount maybe an amenities and
ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ?
Total 52 days, my lord.
52 days. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಪೇಟೆಂಟ್ ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನರಿಶ್ಮೆಂಟ್ ಕನ್ವಿಯನ್ಸಸ್, ಡಿಸಬಿಲಿಟಿ
30% ತಗೊಂಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
30% ತಗೊಂಡು ಹೋಲ್ ಬಾಡಿಗೆ
30%
ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡ್ಬಿಟ್ಟು ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ಇನ್ಕಮ್ 10,000 ತಗೊಂಡಿದ್ದಾರೆ.
ವಾಟ್ ಇಸ್ ದ ಡೇಟ್ ಆಫ್ ದ ಆಕ್ಸಿಡೆಂಟ್?
2017, my lord.
2017 11,000 ಬರ್ಬೇಕು.
11,000.
Why 10 has been taken? ನೀವೇ ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಾ? ನೀವ್ ಎಷ್ಟು ಹೇಳಿದ್ರಿ?
ನಾವು 25 75 ಅಂದ್ರೆ ಮೆಕ್ಯಾನಿಕ್ ಅಂದ್ರೆ
Paragraph number 25, my lord.
25,000
taken 70
10,000.
And regarding this experience, we have produced several documents mechanically.
ಮೆಕ್ಯಾನಿಕ್ ಅಂತ ಅಂದ್ರೆ ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕಾಣ್ಬೋದು. Yes. ಮೆಕ್ಯಾನಿಕ್ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ P30 12 to 13 to ಅಲ್ಲ ಅವರ ಮೆರಿಟ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ. ಮಾಡಿದ್ದಕ್ಕೆ ಅದು ಎಷ್ಟಿದೆ?
ಆಮೇಲೆ ಡಿಸಬಿಲಿಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, that's all. ನಿಮ್ದು ಅಪೀಲ್ ಇದೆಯಾ? ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ನಿಮ್ದೇನಿದೆ? ಹೂ ಇಸ್ he?
100% liability is fixed on KSRTC.
ಮೇಲೆ ಇದೆ ಅಲ್ಲ? Yes. ನಿಮ್ದೇನಿಲ್ಲ? Yes. So and so learned counsel appearing for corporation contended that at the time of the accident, the claimant was riding that motorcycle while speaking in the mobile. He has not noticed that the bus coming from opposite direction. The RW1 in his evidence has categorically stated this aspect of the matter. Tribunal has not considered the same. Secondly, he has contended that the claimant as well as pillion rider petitioner as well as the pillion rider have turned hostile by denying that accident as due to rash and negligent driver of the clearly after fact there is no harsh and negligent driver. What is that this thing, Mr.?
ಯಾರ ತಪ್ಪಿನಿಂದ ಆಗಿದೆ ಅಂತಂದ್ರೆ ಏನು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಬಂದಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ ಹೈಲೈಟ್ ಮಾಡಿ.
ಯಾರು ಹೇಳಿದ್ದಾರೆ?
ಇವರು ಪಿಟಿಷನರ್ ಮತ್ತೆ ಇನ್ನೊಬ್ರು ಪಿಲಿಯನ್ ರೈಟರ್ ಇದ್ದಾರೆ.
Yes.
Paragraph number 17 of the R1 my lord, exhibit R1. Exhibit R1, paragraph number 17.
17?
Hostile ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ for that reason prosecution ಡ್ರಾಪ್ ಮಾಡಿದ್ರು.
Yes. ಅದ್ರಲ್ಲಿ ಕ್ಲೈಮೇಟ್ ಅನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರಾ?
ಹಾ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ
pillion rider have turned hostile in the criminal case. ಅದ್ಯಾವುದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದ್ರನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು ತಂದಿದ್ದೀರಾ?
ಇವತ್ತು ತಂದಿಲ್ಲ.
His ground itself is on that. Yes, ಅದಿದೆಯಾ ನಮ್ಮ ಹತ್ರ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನ ರಿಲೈ ಮಾಡಬಾರ್ದು ಅಂತ. Yes. Without tribunal as not taking into the consideration of. ಅದನ್ನೇನು ಎಕ್ಸಿಬಿಟ್ ಮಾಡಿದ್ದೀರಾ? ಎಕ್ಸಿಬಿಟ್
R1. Judgment of the
not consider the judgment of the
CC 936 of 2017.
Criminal court in CC
936 of 2017. 936 of 2017.
936 of 2017. It's
Civil Judge and JMS
clearly indicates that climate is also contributed to that extent. What is the finding of the tribunal regarding that?
because
ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 15 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ he deposed that he doesn't know because of whose fault the accident occurred. ಅಷ್ಟೇ ಇರೋದು ಸರ್. ಅಷ್ಟೇ
that so and so respondents show that accident is admittedly similar when the accident is admitted. Petitioner contended. ಏನ್ ಇಷ್ಟನಾ? On contrary, respondent denied that negligence on the part of the driver is about. They have contended that accident is caused only negligence. No, the respondent on also show that accident admitted similarly when the accident is admitted, the injury sustained by rider of motorcycle has fell down along with the pillion rider. In respect of quantum, he has contended that even though claimant has claimed that he was earning 50,000 per month as a mechanic, he has not produced any document to prove the same. Therefore, notional income assessed by the tribunal 10,000 is on higher side. Lastly, he has contended that considering that injury suffered by the claimant, and considering that evidence of doctor and medical records, the overall compensation awarded by the tribunal on higher side sought for dismissal of the appeal. Contended that at the time of the accident, the claimant was riding that motorcycle after following all procedure of law and traffic rules, was not using the mobile. No document has been produced to prove that. No evidence has been produced to prove that deceased was using that the claimant was using the mobile at the time of accident. He further contended that stray admission in the criminal case cannot be considered in deciding the negligence in motor vehicles claim. The tribunal, after considering that material available on record, has rightly held that driver of the bus is negligent in causing that accident. In respect of quantum, he has contended that at the time of the accident, claimant was working as a mechanic and earning 50,000 per month. Due to that accidental injury, he can't do his day-to-day work. The monthly income assessed by the tribunal, 10,000, is on lawyer side. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient
52 days.
He was inpatient for a period of 52 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering and other incidental expenses is on lawyer side. Tribunal has not granted any compensation for loss of immunities. Hence, he sought for enhancement of compensation. Heard the learned counsel for the parties peruse judgment and award and original records. The case of the claimants that on 27/6/2017 at about 12:30 p.m. he was proceeding in his motorcycle bearing registration number KA12R5639 along with that pillion rider from Somarpete to Kushal Nagra. When he was riding that motorcycle slowly, after observing the traffic rules and regulation on extreme left side of the road, the driver of the KSRTC bus came in rash and negligent manner, dashed the claimant motorcycle. Due to impact, he fell down and succumbed to that injury. After recovering from the injury, he has filed a claim petition. To prove his case, he has examined himself as PW1. Who is PW4?
PW4 is that artificial limb.
PW3 ಯಾರು?
PW3
Naveen Kumar Hegde, surveyor.
Naveen Kumar, yes, surveyor.
Yes. And himself has PW1 and produced 189 documents In his evidence, he has reiterated the statement made in the claim petition. The respondent has examined Gangadhar yaru, driver.
Gangadhar driver.
Examined driver as RW1 has taken a contention that the claimant was riding that motorcycle using the mobile phone. He has not observing that vehicle coming from opposite direction. He dashed against that bus. Except giving his evidence, he has not examined any other witness to prove that claimant was using the mobile phone at the time of the accident. On the other hand, FIR complaint, charge sheet, and the evidence of PW1 disclosed that driver of the bus alone is negligent in causing that accident. Tribunal, after considering that material available on record, has rightly held that driver of the bus alone is negligent in causing that accident. The evidence of petitioner, claimants, and pillion rider in criminal case. ಏನಂತ ಹೇಳಿದಾರೆ ಅದರಲ್ಲಿ?
ಯಾರ ತಪ್ಪಿನಿಂದ ಆಗಿದೆ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ ಅಂತ. ಯಾರ ತಪ್ಪಿನಿಂದ ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಬಂದಿದೆ.
In criminal case,
ಇಬ್ಬರು ಹೇಳಿದ್ದಾರೆ.
they have. Kara? They have turned hostile in the criminal case. That cannot be considered. That cannot be, that only cannot be considered to held that they have contributed to the extent. Tribunal, after considering that evidence available in MEC case and evidence of the parties, has rightly held that driver of the bus alone is negligent in causing that accident. In respect of quantum, even though claimant has claimed that he was earning 25,000 per month as a mechanic, he has not produced any document to establish the same. Since he has produced that document to show that he was a mechanic, since he is a skilled laborer, the monthly income has to be assessed as 12,000 per month. Tribunal has rightly assessed whole body disabilities 30%. The multiplier applicable to the age group is 14. Accordingly, loss of future earning due to disability has been reassessed as follows.
12,000 into 12 into 14 into 30%, 6 lakhs, 4,800.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ 25% ಬೇಕಂದ್ರೆ 30% ಇದೆ.
30% again ಬರಲ್ಲ. ಆಮೇಲೆ ಏನು ಆಗಿಲ್ಲ, ಕೈ ಬರೀ ಸ್ಕಿನ್ ಮಸಲ್ಸ್ ಹೋಗಿದೆ ಅಷ್ಟೇ. ಐ ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ ಫೋಟೋಗ್ರಾಫ್. Yes. ಅದಕ್ಕೆ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಎಲ್ಲ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
1 lakh.
Due to that accident, claimant has suffered grievous injury He was inpatient for a period of
52 days.
52 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Loss of income during the later period kotilva.
Gottilla.
He has suffered lot of pain during the treatment period. Huh? Yeah, loss of income during that later period el kottidare charter
Gottilla.
considering that evidence of doctor and injury suffered by the claimant
50,000.
nourishment to conveyance kottidare attendance charges kottidare disability kottidare future expenses kottidare. The claimant is also entitled for loss of income during the later period for a period of 6 months. And he is also entitled for loss of amenities, sum of rupees 60,000. Loss of amenities 75,000. Other head, compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal filed by that corporation is dismissed. Appeal filed by the claimant is allowed in part. Yes.
First matter I'll undertake to file wakar. ನನ್ನ ಹೆಸರು ಇಲ್ಲ ಸುಮ್ಮನೆ ಪ್ರದೀಪ್ ಅವ್ರದಿದೆ. ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ. ಮೈ ನೇಮ್ ಇಸ್ ಶೋನ್.
ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀವಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್?
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ.
ಜೀವನ್ ಸೋನಾಲಿ ಸಿ ಯಾರು ಅದು R2?
R2 ಗೆ ಓನರ್ ಓನರ್
R3 ಗೆ ಏನಾಗಿದೆ ರೀ?
R3 connected matter ಶರಣಪ್ಪ ಗೌಡ. ನಾನು ಫಸ್ಟ್ ಮ್ಯಾಟರ್
ಬಿ ಪ್ರದೀಪ್ ಅಂತ BK ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ.
ಬಿ ಪ್ರದೀಪ್ ಹೆಂಗ್ ಬರ್ತಾರೆ? ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಇದೆಯಾ?
ಇನ್ಶೂರೆನ್ಸ್
ಕಂಪನಿ.
ಇನ್ಶೂರೆನ್ಸ್.
ನೀವ್ ಯಾರಿಗೆ?
ನಾನು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ ಸ್ವಾಮಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ.
No, you are appearing for insurance company. That instead of B Pradeep, you are appearing.
Yes.
ವಕಾಲತ್ ಹಾಕಿದಾರ ನೋಡಿ B Pradeep.
ಇಲ್ಲ.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ, ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
Wait. ವಕಾಲತ್ ಪ್ರದೀಪ್ ಹಾಕಿದಾರ? Yes, office is directed to delete the name of B Pradeep and show the name of Sharnappa Gowda for R3. First, amount in deposit is transferred to the tribunal. Yes. What is that? Tomorrow. Yes. Afternoon. Next week. Yes, next week. Either today or next week. Yes. You want time? Yes, next week. Yes, entry order idya? Entry order granted earlier is extended till next date of it. 50? Yes. Interim order granted earlier is extended till next date of it. If there is, yes.
ಸೋಮವಾರ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇತ್ತು, ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ಏನಾಯ್ತನ?
ಅದು ಅಲೋ ಆಗಿದೆ ಸರ್, ಅದು ಸಬ್ಸ್ಟಿಟ್ಯೂಷನ್
ಅಲ್ಲ ಡೇಟು
ನವೆಂಬರ್ 20th 2011.
2011 ಒಳಗೆ ಪಬ್ಲಿಷ್ ಮಾಡದ?
ಅಲ್ಲ, ಹಿಯರಿಂಗ್ ಡೇಟ್ 2011, 23/10 ನೀವು ತಗೋಬೇಕು.
23/10 ಒಳಗ?
ಮಂಡೇ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ ಬರಲ್ಲ ಅಲ್ಲ ಸರ್? ನನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೆಲಿವರಿ ನಂದು ಅದಕ್ಕೆ ಸ್ಯಾಟರ್ಡೆ ಹಂಗೆ ಮೊನ್ನೆ ಅಟ್ ಈಸ್ ಬಾಳ ಕಲಿತು ಮತ್ 6 ತಿಂಗಳು ಬರಕ್ಕಾಗಲ್ಲ.
ಇವಾಗ ಇವನಿಲ್ವಾ
ವೈರೇಶ್
ಯಾರು
ಇದ್ದಾರೆ, ಬೇರೆಯವ್ರು ಇದ್ದಾರೆ. ನಮ್ ತಂದೆ ಬರ್ಬೇಕು ಅದಕ್ಕೆ. ಮಂಡೇ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ ಒಂದ್ ಚಾನ್ಸ್ ತಗೊಂತೀನಿ. ನಾಳೆ ಬೆಳಿಗ್ಗೆ. ಥ್ಯಾಂಕ್ ಯು.
ಹೇಳಿ. ಮೆಮೊ ಬಂದಿಲ್ಲ. ಮೆಮೊ ಬುಕ್ ಕೊಟ್ಬಿಡಪ್ಪ ಅವ್ರು. ಎಲ್ಲರಿಗೂ ಮೆಮೊ ಬುಕ್ ಕೊಡು. ಏನಪ್ಪ ಎಲ್ಲ ಪಾಸ್ ಅವ್ರೆ ಮಧ್ಯಾಹ್ನ. ಎಲ್ಲಿ ಕಾಣಿಸ್ತಾ ಇದೆ ಮೆಮೊ ಬುಕ್ ಕೊಡಿ ಅವ್ರಿಗೆ. ಮೆಮೊ ಹೋಗಿಲ್ವೇನಪ್ಪ ಇನ್ನು? ನನ್ಗ ನಿಂಗೊಂದು ಇದು ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ವಾ? ಸಿಪಿ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲಪ್ಪ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತು. ಕೊಟ್ಬಿಟ್ಟ ನೀನೇ ಕೊಟ್ಬಿಟ್ಟ ಈ ಹುಡುಗಿಗೆ? ಅದೇಪ್ಪ ಎನ್ಆರ್ಗೆ ವೀಕ್ ಆಯ್ತಾ? ಹೋಗಿದ್ಯಾ ಸರ್?
ನೀವು ಹೋಗಿ ಇರುತ್ತೆ. ಸೈನ್ ಹಾಕಿದ್ರಿ ನೋಡಿ.
ಅದು ಫೋಟೋ ತಗೊಳ್ಳಿ, ಒಂದ್ಸಲ ರಿಮೈಂಡ್ ಮಾಡಿ. ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ RJ ಹತ್ರ ಹೋಗಿ. ಅವರು ಮೆಮೊ ಅವರು ಆಮೇಲೆ ತರಿಸ್ತಾರೆ, ಎಲ್ಲಿದ್ದು ತರಿಸ್ತಾರೆ. ಮಾಡ್ಬೇಕು ಸರ್, ಮಾಡಿ ಇಲ್ಲಿ ಕೊಟ್ಬಿಡಿ ಸರ್ ಅವ್ರಿಗೆ. ನನ್ ಕಸ್ಟಡಿ ಅಲ್ಲ ಅವ್ರದ್ದು. ಓಕೆ ಸರ್. ಇಲ್ಲ ಏನ್ ಬಿಡದೆ ಜೊತೆಗೆ ಕುಂಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಸರ್ನ? ಬಿಟ್ರೆ ಇವತ್ತು ಹೋಯ್ತು ಅಂತನಾ? ಅದಕ್ಕೆ ನಾನೇನಪ್ಪ ಜೊತೆಗೆ ಕುಂಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ. ನೋಡಿ ಸರ್, ಅವ್ರು ಆ ಕಡೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕುತ್ಕೊಂಡು ನಿಮ್ಗೆ ಮಧ್ಯೆ ಕುಂಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 2:30 ತನಕ ಬಿಡಂಗಿಲ್ಲ.
ಅದು 7 ಮಂತ್ ಬರುತ್ತೆ. 7 ನಾವು ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡು ಏನ್ ಇನ್ಕಮ್ ಬರುತ್ತೆ 17,000 ಸಮಥಿಂಗ್ ಬರುತ್ತೆ. ಇಂಟು 12 ಇಂಟು 18 ಮಲ್ಟಿಪ್ಲೈ 17,000 ಸಮಥಿಂಗ್ ಬರುತ್ತೆ. ಅಲ್ಲ ಅವರು ಹೇಳಿದ್ರು, ಆಯ್ತು ಸರ್ ಹೇಳ್ತೀನಿ. ನಾವು 6 months ಲೆಕ್ಕ ಆಗಿದೆ, ಅದು 19,000 ಸಮಥಿಂಗ್ ಬಂತು. ಇಲ್ಲ 7 ತಿಂಗಳಿಗೆ ಲೆಕ್ಕ ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು. ಸೊ 17,000 ಬರುತ್ತೆ. ಅದು 17,000 ಪ್ಲಸ್ ಅದು ಅವರು ರೆಕಾರ್ಡ್ ನೋಡೋಣ. ನಾನದು ಬಟ್ ಆದ್ರೂ ನಾವು ಮಾತು ಹೇಳ್ಬೇಕು. ಆಮೇಲೆ ಹೇಳಿದಿರ ಮಾಡಿದ್ರೆ ಏನ್ ಕಾಣಿಲ್ಲ ಸರ್. ಬೇರೆಯವ್ರಿಂದ ಸೀನಿಯರ್ಸ್ ಇದ್ರೆ ನಾವು ಸ್ವಲ್ಪ ನೋಡ್ಲೇಬೇಕು.
No problem.
List ಮಾಡೋದೆಲ್ಲ ಬೋರ್ಡ್ ನಾವು 2 days ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಏನಿದೆ ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಮಾಡಿ ಹೋಗಿ ನೀವು ಫ್ರೆಶ್ ಆದ್ರೆ ಬುಕ್ ಬ್ಯಾಚ್ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡಿ. ಸುರೇಶ್ ಒಂದು ಬುಕ್ ಅಂತ ತಗೊಂಡೋಗಿ ಕೊಡಪ್ಪ. ಮೆಮೊ ಕೊಡ್ಬೇಕಂತ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ, ಇವ್ನು ಬಂದ್ಮೇಲೆ ಬರ್ಕೊಡ್ತಾನೆ. ಟೂ 2:30 ಒಂದು ಮೆಮೊ ಕೊಟ್ರಾ? ಇದು ಒಂದು ಕೊಡ್ಬೇಕು, ಬರ್ಸ್ಕೊಂಡೋಗಿ ಕೊಡಪ್ಪ. ಕೊಡ್ಬೇಕಂತ ಹಾ ಕೊಟ್ಟಿದ್ವಿ, ಕೊಡಿ ಕೊಡಿ ಅಂತ. ಕೊಡ್ಬೇಕು ಅಂತ ಅವಾಗಲೇ ಮಾಡಿದ್ರು, ಸಿಕ್ತು. ಒಂದೆರಡು ದಿನ ಮೆಮೊ ಕರೆಕ್ಟ್ ಆಗಿ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಕುದ್ದಿರ್ತಾರೆ ಅವ್ರು ಯಾರು ಸುಮ್ಮನೆ ಮೆಮೊ ಹೋಗಿಲ್ಲ ಅಂತ. ಏನಪ್ಪ ಹೌದು ಮಾಡಿ.
ಇದನ್ನ ನಾನು ಹೇಳ್ತೀನಿ, ಈ ತರ
ಏನಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ರೀಕಾಲಿಂಗ್ ಅಂದ್ರೆ ಇದು DNP ಆದಾಗೆಲ್ಲ ರೀಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಆಗಿದೆ,
ಮೆರಿಟ್ ಮೇಲೆ ಆಗಿದ್ದ.
ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ಬಂದಿದೆ, ಅವರೇ ರೀಕಾಲಿಂಗ್ ಆಗ್ತದೆ.
ಹೌದು ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ಬಂದಿದೆ. ಈಗ ಅಡ್ವೊಕೇಟ್ ಬಂದು ಹೇಳೋದು, ಅಡ್ವೊಕೇಟ್ ಯಾರು ಹೇಳಿ ಅವರು?
ರೆಸ್ಪಾಂಡಿಂಗ್ ಗಿರಿಜಿ.
ಅಲ್ಲ ನಿಮ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಏನಕ್ಕೆ ಅಂತ ನಾನು
ಅಬ್ಜೆಕ್ಷನ್ ಆದ್ರೆ ಇದು ಮೆರಿಟ್ ಮೇಲೆ ಆಗಿದೆ.
ಹಾ
ಸಾಹೇಬ್ರು ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ಆಗ್ತೀವಿ. ಈಗ DNP ಆದಾಗ ಡಿಸ್ಮಿಸ್ ನಾನ್ ಪಾಸಿಟಿವ್
ಮೆರಿಟ್ ಮೇಲೆ ಆದಾಗ ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಪುಟಪ್ ಮಾಡಲ್ವ? ಮತ್ತೆ ಆ ಪೇಪರ್ ಏನ್ ಮಾಡ್ತೀರಾ? ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಮುಂದಕ್ಕೆ ಹಾಕ್ಲೇಬೇಕಲ್ಲ, ಅದೇ ಹೆಂಗೆ ತಿಡ್ತೀರಾ?
ಅಲ್ಲ ಇಡಲ್ಲ, ಕೋರ್ಟ್ ಮುಂದೆ ಆಗ್ತದೆ, ಅದನ್ನ ಡೈರೆಕ್ಟ್ ಇವಾಗ ರೀಕಾಲಿಂಗ್ ಆಗ್ತದೆ.
ಪ್ರಕಾರ ಅವ್ರಿಗೆ ಅವತ್ತೇ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು ಸಾಯಂಕಾಲ, ಈಗ ಗ್ಯಾಪ್ ಆಗೋದು, ಗ್ಯಾಪ್ ಫಿಲ್ ಅಪ್ ಮಾಡ್ಬೇಕು. ನಿಮ್ಗೂ ಡೌಟ್ ಇದೆ. ಈಗ ಅವರು ಬಂದು ನನಗೆ ಹೇಳಿದ್ರು, ಸರ್ ಅವತ್ತು ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನ ಅವ್ರಿಗೆ ಹೇಳಿ ಅಂತ. ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದೆ, ಬಟ್ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಆ ಥರ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ. PS ಮೇಡಮ್ ನಾನು ಗಮನಕ್ಕೆ ತಗೊಂಡ್ಬಂದು
ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಲ್ಲ, ಈ ತರ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅದು ಮಾಡಿ
ಅಷ್ಟೇ. ಈಗಲೇ ಹೋಗಿ ಇಬ್ರು ಇರ್ತಾರೆ, ಸಾಹೇಬ್ರು ಇರ್ತಾರೆ, ಮೇಡಮ್
ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡಿ.
ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಗ್ಯಾಪ್ ಆಗೋದು, ಬೆಳಗ್ಗೆಗೆ ಹಾಕಿದ್ರೆ ಹಿಂದೆ ನಾನು ಹೇಳ್ತೀನಿ. ಅಥವಾ 15 days ಬ್ಯಾಕ್ ಒಂದು ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಯಿತು, ಆಬ್ಸೆಂಟ್ ಅಂತ ತೋರಿಸಿ ಮೆರಿಟ್ ಮಾಡಿದ್ವಿ. ಅವರು ಸಂಜೆ ಬಂದು ನನ್ನ ಕೇಳಿದ್ರು, ಹಿಂಗಾಗಿದೆ ಅಂತ. ತಿರ್ಗಿ ಸಾಹೇಬ್ರ ಹೇಳುವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು. ಈ ಥರ ಇನ್ಫಾರ್ಮೇಶನ್ ಗೊತ್ತಾಯ್ತು, ಆರ್ಡ್ರ್ ಎಲ್ಲ ಆಗೋಯ್ತು, ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ನೀವು ಐ ಹಾಕಿದ್ರಿ. ಈಗ ಐ ಹಾಕಿರೋದು ಆ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಏನು ಹೇಳ್ತಾರೆ, ಮೆರಿಟ್ ಮೇಲೆ ಆದಾಗ ರೀಕಾಲಿಂಗ್ ಬರೋದಿಲ್ಲ, RP ನೇ ಹಾಕ್ಬೇಕು ಅವರು, ನಾವು ಹೇಗ್ ಮಾಡ್ಬೇಕು ಈಗ ಅಂತ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್. ಅದಲ್ಲ ಇದ್ಯಾವುದೋ ಬೇರೆ. ಆಮೇಲೆ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಬಂದು ನನಗೆ ಹೇಳಿದ್ರು, ಸರ್ ಹೇಳಿದ್ರು ಇಲ್ವೋ ಸಾಹೇಬ್ರು, ಹೇಳಿದ್ರಪ್ಪ ಅದಕ್ಕೇನಂತ ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಹೇಳಿದ್ರು, ಮತ್ತೆ ಅವ್ರು ಪೆಂಡಿಂಗ್ ಮಾಡ್ಕೊಡ್ತಾರೆ ಹೇಳಿ, ಆಯ್ತು ಹೇಳ್ತೀನಿ ಬಿಟ್ಟು ಬಂದಾಗ ಅವ್ರು ಪೆಂಡಿಂಗ್ ಮಾಡಿ ಬಂದ್ರಿ, ನೋಡಪ್ಪ ನಡೆದಿದ್ದು ನಿಜ, ಬಟ್ ಗ್ಯಾಪ್ ಆಗೋದು ಸಾಹೇಬ್ ಜ್ಞಾಪಕ ಇರ್ತದೆ, ಈಗ ಗ್ಯಾಪ್ ಆಗೋದು ಹೇಳಿ ಸಾಹೇಬ್ ಹೇಳಿ ಹೆಚ್ಚು ಕಮ್ಮಿ ವಾರ 15 ದಿವಸ ಆಗುತ್ತೆ. ಅದನ್ನ ಸಾಹೇಬ್ ಗಮನಕ್ಕೆ ಇನ್ನೊಂದ್ಸಲ ತರಬೇಕು. ಅದೇ ಅಲ್ಲಮ್ಮ, ನೀವು ಫಸ್ಟ್ ವಿಚಾರ ತಿಳ್ಕೊಳ್ಳಿ ಏನು ಯಾಕೆ ಅವ್ರ ಆಫೀಸ್ ಪ್ರೊಸೀಜರ್ ಏನು, ಆಮೇಲೆ ಸಾಹೇಬ್ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಪೇಪರ್ಸ್ ಯಾವ್ದು ಪೇಪರ್ಸ್ ಇಂಥವು ಯಾವುದು ಸ್ಕೂಟನಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಫೈಲ್ ಸ್ಕೂಟನಿ ಆದಾಗ ಯಾವುದು ಅಮೋನೇ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಬಾರ್ದು, ಅಮೋನೇ ಕೇಳಬಾರ್ದು. ಏನಿಲ್ಲ.
61
ಯಾರು ಇಲ್ವೋ?
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ ಏನು ಒಂದೇ ಇರೋದಲ್ವಾ?
ಇದೇ ಒಂದಿದೆ ಸರ್, ಅದನ್ನ ಯಾರು ಇಲ್ಲ ಜನ
ಅಲ್ಲ ನಾನೇ
ನೀವೇನ?
ಅದು ಮುಗಿಸ್ಬಿಡಿ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ.
ಅಲ್ಲ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾರೆ.
ಕರೆಕ್ಟ್. ಪಾಸ್ ಓವರ್ ಮಾಡೋ ಬದಲು ಹಿಂಗ್ ಮಾಡೋದಾದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಅದೇ ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ. ಅದನ್ನೇ ತೆಗೆದು ಬಿಟ್ರೆ ನಾವು ಹೋಗ್ಬೋದಲ್ಲ. ಹಾ
ಸರಿ ಸರ್, ಆಯ್ತು. ವೇಟ್ ಮಾಡ್ಸಲ್ಲ ನಿಮ್ಗೆ. ಹೌದಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಏನಾಯ್ತು?
37.
ನಾನು ಒಂದು RSC ರೀಚ್ ಆಯ್ತು ಅಂತ ಅಲ್ಲಿಗೆ ಓಡೋದೆ, ಬರೋಷ್ಟೊತ್ತಿಗೆ
2 weeks.
2 weeks.
ಕೊಡ್ಬೇಕಂತ ಮಾಮೂಲಿ ನೀವು ನಾವು ಹೆಂಗ್ ಕೊಡ್ತಾರೋ ಹಂಗ್ ಕೊಡ್ಲಿ. ಹೆಂಗ್ ಕೊಡ್ತೀವಿ ಹಂಗ್ ಕೊಡ್ಬೇಕಂತ. ನಾಳೆಗೆ ಹಾ ನಾಳೆ ಕೊಟ್ಟಲ್ಲ ಅವಲ್ಲ ಹೊಲ ಕೊಟ್ಬಿಟ್ರು. ಏನೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರಂತೆ ಅದಕ್ಕೆ ಹಾಕಿದಾರೆ ಕೊಡಕ್ಕೆ.
Recalling. ಏನಾಯ್ತು ನಾನು ಎದ್ದು ಸೀಟಿಗೆ ಬರೋತ್ತಿಗೆ ಸಂಜೆ ಕೇಳ್ತೀನಿ. ನೀನ್ ನಾಳೆಗೆ ಅಂತಾನೆ ಇಲ್ಲ
ಹೇಳಿದ್ರಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ ಆಯ್ತು ಬಿಡಿ ಸರ್ ಹೇಳ್ತೀನಿ. Serial number 60, Veena TN for petitioner, Pundika Ishwara Bhatt, government advocate.
Yes, coming. Pass on.
Password. Monday.
Yes, coming. Monday.
Monday. Yes. This matter on Monday. Interim order granted earlier is extended till next date of the.
Fast over matter, serial number 2, Revati Adinath Narde for petitioner, connected matter, Madhukar M. Deshpande.
We'll have it after vacation. Better. Can't be, we'll have it after vacation. Nothing will happen till 14th.
So we filed a memo there.
In that event, I will draw my lord's attention to today's memo. The type of allegation leveled in that particular. Where memo is filed? With the CP, which was withdrawn by them. We'll do one thing, we'll have it on 14th. Nothing will happen another 2 weeks. They in between holidays and all there. We'll have it on 14th. Yes, release this matter on. They will not, they knows that, see that is. No, council has responded for your this thing. He said that he will not do it. He has not done till today, no, after that. Yes. No, see, when is the matter? 24. See, his council is there. He said that he will not do anything. We'll have it on after vacation, 14th or 15th. Yes, leave this matter on 15th. Yeah.
Great. Bill number 18, Gurudeva Prasad KT for appellant, connected matter. S. Nagaraja, Ravi S. Samprati.
Yes.
ಒಂದು ಕೇಸ್ ಆಫ್ ಇಂಜುರೀಸ್ ಇನ್ನೊಂದು ಡ್ಯಾಮೇಜಸ್.
Now the serial number 18 ಅಲ್ಲ ಇವರು who is S. Nagaraj? Owner, only you are the contesting, Mr. Ravi.
Please.
Yes. First matter death case,
injury.
8947 death ಅಂತ ಹಾಕಿದಾರಲ್ಲ ವೆಹಿಕಲ್. Yes. ಎರಡು ಒಂದೇ ಇದ್ರಲ್ಲೇ
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಎಸ್, ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಯಾರಾ? ಹ್ಮ್. Hmm. 3 months. What is the finding of the tribunal regarding that?
Para number, page number 12, para number 19. Global ಆಗಿ 60,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
It is entitled to maintain this petition. Result petitioner has paid 1 lakh for the repairs, damages of the vehicle, irrespective of the petitioner reimbursing the part of that amount. Petitioner is entitled for the compensation balance amount of rupees 1 lakh due to repairs and vehicle is in the garage. Adano serse. Vehicle in the garage. As such, petitioner has lost the income of the petitioner claiming amount 80,000. That you are claiming that total compensation is less. In that period, it has granted. What is your claim?
40,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇ no, ಇಲ್ಲಿ 60,000. As per petitioner has lost income. Petitioner claim amount is 60,000 for
loss of rent.
60,000 ಕೊಟ್ಟಿದ್ದಾರೆ. What is your claim?
40, ಇನ್ನೊಂದು 20,000 ಕೊಡ್ಬೋದು.
ಅದು ಇಲ್ಲಿ ಹೇಳಿರೋದ್ರನಾರ ಅಷ್ಟಿಷ್ಟು ಕೊಡ್ಬೇಕಲ್ಲ.
20,000 ಮಾಡ್ಬೋದು ಅಡಿಷನಲ್.
ಇನ್ನೊಂದ್ರಲ್ಲಿ
ಬರೀ ಇನ್ಕಮ್ ಒಂದೇ. Income to be considered at 9,500, 8,000 consider ಮಾಡಿದ್ದಾರೆ.
Petitioner 3 lakhs with interest in excluding the figure respondent 9%.
Page number 10, my lord. Page number 10 of the judgment.
1,77,000 ಕೊಟ್ಟಿದ್ದಾರಾ? 1,77,000 ಅಂತಂದ್ರೆ will make it 2 lakhs. ಸರಿ ಆಗುತ್ತಲ್ಲ ಅಲ್ಲಿ. ಇದರಲ್ಲಿ which is that second matter?
Para number 10, my lord. Page number 10, sorry. Para number 16.
Yes.
ಡಿಸಬಿಲಿಟಿ 100% ಸರಿಯಾಗಿ ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ಕಮ್ 8,000 ತಗೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬೀನ್ 9,500.
36% disability to rate 18% whole body. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
12%. 1/3 ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡಿದ್ದಾರೆ.
12%. ಇನ್ಕಮ್, ವಾಟ್ ಇಸ್ ದಟ್ ಇನ್ಕಮ್?
8,000 ತಗೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಶುಡ್ ಬಿ 9,500.
Yes. 2016.
ಬೇರೆ ಎಲ್ಲ pain and
days you are in that hospital? 4 days.
My lord, the compensation insofar as other rates is concerned is quite reasonable. In fact, pain and suffering 75,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
75,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ pain and
ನರಿಶ್ಮೆಂಟ್
suffering ಗೆ
ಅಟೆಂಡೆನ್ಸ್
75,000
ಚಾರ್ಜಸ್
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕನ್ವೆನ್ಸ್ ಚಾರ್ಜಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಮ್ಯುನಿಟೀಸ್ ಒಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ಬೇಕು.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಅಲ್ಲ ಅಮ್ಯುನಿಟೀಸ್ ಜಾಸ್ತಿ ಆಗ್ಬೇಕಂದ್ರೆ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಲ್ಲೇ 75,000 ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ವೈ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ವಾಟ್ ಇಸ್ ದ ಇಂಜರಿ?
ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಹ್ಯೂಮರಸ್ ಒಂದೇ.
Where is that? Where is the discussion regarding that?
Para number 13, my lord. Your lordship will get it at page number 8. The exhibit P11 is 2 X-ray produced by PW1 for sustaining the proximal humerus fracture. The doctor PW1, an orthopedic surgeon at Boring Lady Curzon Hospital, so and so. PW1 physically found proximal humerus so and so. In that respect, exhibit P24 X-ray is produced along with exhibit P3, the hospital OPD card. All these days, PW1 must be attended by his family and so and so and ಹಾಕ್ಬಿಟ್ಟು 75,000 ಅಂತ ಮಾಡ್ತಾರೆ. Petitioner must have suffered acute pain and suffering for the type of the injury. Normally, for a fracture of femur or humerus, this honorable court grants only around 30 to 40,000 rupees. They granted 75,000. So,
ಇದು 9,500. Yes, I will consider. What is that?
ಅದೊಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಲೇಟರ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಎಸ್ ಲೇಟರ್ ಪೀರಿಯಡ್ ಅಷ್ಟು. ಎಸ್ ತಳಿ. ಫಸ್ಟ್ MFA is for ಇದಲ್ಲ
damages.
So and so learned counsel appearing for claimant has contended that due to that extent their vehicle was suffered in a damage and he has spent 1,29,999 for repairs of the vehicle and 1,55,756 for a loss caused to that claimant during the period when that vehicle has been.
I'm sorry. The actual damages is 2,91,974, out of which 1,55,756 was paid by his insurer. The balance would be 1,29,000.
Yeah, that's what they said. Balance only we are, yes. Damage loss caused to them owner when the vehicle was kept idle in garage on 26/2/2016 till 24/5/2016. Hence he sought for enhancement of compensation. Per contra, Sri Ravi Learned Counsel appearing for insurance company has contended that as per exhibit P20, the total cost of that repairs of the vehicle is 2,91,975. Out of that, he has reimbursement from insurance company of rupees 1,55,756. The remaining amount of rupees 1,29,990 has been awarded by the tribunal. For loss of income when the vehicle was in the garage from 26/2/2016 to 24/5/2016, the tribunal has awarded 60,000 rupees. The overall compensation awarded by the tribunal just and reasonable. Sought for dismissal of the
interest 9%.
Bill and that interest awarded by the tribunal 9% is on higher side. Heard the learned counsel for the parties peruse judgment and award. It is not in dispute. The claimant's vehicle car bearing registration number KA40A0286 has suffered a damage in a road traffic accident occurred on 21/2/2016 due to rash and negligent driving of driver of car bearing registration number KA3053 B9655. The claimant has produced document to show that he has spent 2,91,974 for repairs of that vehicle. Out of that, the Reliance Insurance Company has reimbursement of rupees 1,55,756. The remaining amount of rupees 1,29,999 has been granted by the tribunal. In addition, due to the vehicle was in the garage from 26 to 2016 till 24/5/2016, he has suffered a loss. Tribunal has awarded compensation of rupees 60,000 is on lawyer side. Considering that loss cost to the petitioner, I am of the opinion that the overall compensation awarded by the tribunal, 1,77,000 has to be enhanced to 2 lakhs. The enhanced compensation amount carries 6% interest. In MVC 4936 of 2016.
4935.
35, first, yes, 35. So and so learned counsel appearing for the claimant contended that at the time of the accident, he was earning yesterday. Contended that the notional income assessed by the tribunal, 8,000 is on lawyer side. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 4 days. He has suffered 15,000. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses are lawyer inside. Tribunal has not granted any compensation for loss of income during the later period. Shri Ravi Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income must be assessed. Tribunal has rightly assessed notional income of the claimant as 8,000 per month. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses are just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the partition. There was judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on so and so date due to rash and negligent driving of driver of car bearing registration number KA 53B9655. Due to the accident, claimant has suffered the following injury. Considering that injury suffered by the claimant and evidence of doctor, tribunal has assessed whole body disabilities, 12% is just and reasonable. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines. For the accident occurring 2016, notional income has to be considered as 9,500. The multiplier applicable to that age group is 17. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 17 into 12%, 2,32,560.
Due to the accident, claimant has suffered the following injury. was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 15,000 to 25,000. The claimant is entitled loss of income during the later period for 3 months. Enhanced compensation amount carries 6% interest. Accordingly, appeal is allowed in part. Judgment and award passed by the tribunal is modified.
Connected matter.
15 days delay is controlled. Yes, either connected or you have to take notice, Ravi. Ravi Samprati is directed to take notice for
2 weeks time may be granted. I'll file wakala.
Yeah,
R2, sir.
R2, 4 weeks time is granted to file wakala. Please.
Number 19, Gurdeva Prasad KT for appellant, D. Vijay Kumar.
Yes. After vacation. Yes. Reach this matter after vacation.
Serial number 23, Rajaram S for appellant, Ravish Bendy.
Yes. Ravish Manila. Yes. ಬೆಳಿಗ್ಗೆ ಇದ್ರು ಅವ್ರು ರಾಜಾರಾಮ್.
ಅವರು ಇದ್ರು, ಮಧ್ಯಾಹ್ನ ಇವರು.
ಪಾಸ್ವರ್ಡ್ ನೋಡೋಣ ಬರ್ತಾರೆ.
Serial number 25, PM Siddhamalappa for petitioner.
Court fee ne ಕಟ್ಟಿಲ್ವಾ? Yes, none appear for the petitioner. Finally, 2 weeks time is granted to comply office objection.
Serial number 45, Murali BS for petitioner.
Yes. Yes, Mr. Submission of learned counsel for petitioner is accepted. Office objection is overruled. The memo filed. The petitioner has filed a memo enclosing that notification. Same is taken on record. The office objection is overruled. Yes. Hmm. Nineteen? 79. Hmm. Hmm. Hmm.
After the expiry of 15 years, but on 25/8/1994.
1994 ಅಂತ ಅಂದ್ರೆ limitation ಏನ್ ಬರಲ್ಲ, but you have to take a permission. Yes. Therefore, that condition is immaterial.
25/8/1994 is decided. But who decided that the father and one of his sons, that is the fourth respondent there, was also a significant. After 16 years, on 21/7/2010.
Yes.
The application is filed by the fourth respondent.
Where is that DC AC order?
AC order, next G not page 51.
50.
Sorry, page 53.
53. 2010. ಎಷ್ಟು ಯಾವತ್ತು ಫಸ್ಟ್ ಸೇಲ್?
25/8/1994.
94 ಅಂತ ಅಂದ್ರೆ 6 + 10 16 years. What is the decision of the AC?
Yes.
Restore. DC has confirmed.
DC has also referred not to the amended clause that is not final.
Yes. Or issue notice. Government advocate is directed to take notice for 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate. Issue emergent notice to respondent number 4. Stay of annexure G till next date of it.
Serial number 48, Sri Vidya GK for appellant. B.S. Sridhar.
ಅದೇನ್ರಿ DS Sridhar, yes. Office is directed to show the name of counsel for respondent number 2 as DS Sridhar in the cost list. Please this matter after 2 weeks.
Serial number 55, Kailash Shankar PS for appellant. N. Krishnaswamy.
Yes, Mr. No, you are saying that, additional?
Salary.
Huh.
Credited with the, deceased account is 17,537. Date of accident is 31/12/16. So 112 ಇಂದ 27 ಬರಬೇಕು 17,537 ರೂಪಾಯಿ salary credited. That is also good. So even that amount are taken into consideration. But income.
Now, what is the criminal has taken?
Criminal 115,000.
15,000. Last month is 17,000. Average ತೆಗೆದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ?
Some 17,000 something.
ಅಷ್ಟೇ ಬರುತ್ತೆ ಎರಡು.
ನಾವಿಬ್ರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಅಷ್ಟನ್ನು ನೋಡಿದ್ದಕ್ಕೆ ಅವರೇಜ್ ಮಾಡಿದೀವಿ. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಪಾಯಿಂಟ್ ಹೇಳಕ್ ಹೋಗ್ತಿದ್ದಾರೆ, ಅದು ಬೇಡ ಅಂತ.
ಎಷ್ಟು ನೀವು ಒಟ್ಟು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ?
ನಾವಿಬ್ರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಇಟ್ಟಿದೀವಿ.
17,000.
138.
One calculation. ನಾನು 17,537 ತಗೊಂಡೆ.
ಹೆಂಗೆ?
This is
No, now that average ತೆಗೆದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? 6 ತಿಂಗಳು ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಅದರಲ್ಲಿ.
17,120.
No, ಬೆಳಿಗ್ಗೆ he has argued something.
ಅದನ್ನೇ ಹೇಳಿದ್ರು.
No. No, you leave it. See, on 4/5/2016 to 3/1/2017, 1,19,972 divided by 6 ಎಷ್ಟಾಯ್ತು?
7. 7. ನಾ ಹೇಳ್ತಿರೋದು 7 months ಆಗುತ್ತೆ.
7 months. Wait, mister. ಎಷ್ಟು months ನೀವು 6 ಅಂದ್ರಿ, ನಾನು 6 ಅಂದೆ. ಎಷ್ಟು months ಆಗುತ್ತೆ ಆಕ್ಚುಲ್ ಆಗಿ?
7 months.
7 months ಆದ್ರೆ 7 ಇಂದ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. 7 ಇಂದ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? ಸಿ ಅವ್ರು ಹೇಳಿದ್ರು 7 months ಅಂತ ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಎಷ್ಟಾಗುತ್ತೆ
ಆಗೋದು ಅಷ್ಟೇ. 5ನೇ ತಿಂಗಳಿಂದ 12ನೇ ತಿಂಗಳಿಗಾದ್ರೆ 7 ತಿಂಗಳಾಯ್ತು.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಆಯ್ತು.
ಅದನ್ನ ಹೇಳಿದ್ರೆ ಸಾಕು.
He was argued. See, this is a quote. Not that Krishnaswamy said I have to take 7 or you said I have to take 8. You have to say what is the record says. Record says 7. That's what Krishnaswamy is also saying. Instead of that, you are saying that Krishnaswamy is saying 7. Then I said I can't accept what Krishnaswamy said. No, Mr. Counsel, in the absence of the other side, you have argued tribunal has taken this by dividing. This is 19,000. Will trust the council. I have not calculated. I said 6. Why you want other side means if anything is wrong from one side, other has to be. Now he has clarified it is not 6, it is 7. Now it is
May, June, July, August, September, October, November, December. ಇವ್ರೇನಾದ್ರು ಮಾಡಿದ್ರೆ 8 ತಿಂಗಳಾಗುತ್ತೆ. ನಾನು 7 ತಿಂಗಳು ಸಾಕು ಅಂತಿದ್ದು, ನೀವು ಹೇಳಿದ್ರಲ್ಲ
3 ಜನವರಿಗೆ ಆಗಿದೆ.
7 ತಿಂಗಳು
ಕರೆಕ್ಟ್ ಇದೆ. 7 ಕರೆಕ್ಟ್ ಇದೆ.
ಆಲ್ಮೋಸ್ಟ್ ಅವರು MESCT ಅವರೇ ಕರೆಕ್ಟ್ ಅನ್ಸುತ್ತೆ. 15,000 ತಗೊಂಡಿದ್ದಿ.
17,138 ಅಷ್ಟೇ. ಅದೊಂದೇ ಗ್ರೌಂಡಾ? ಎಸ್, ಮತ್ತೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
ಆಮೇಲೆ ಒಂದೇ ವೈಲ್ ಕ್ಯಾಲ್ಕುಲೇಟಿಂಗ್ 9% ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಾಗ 9% ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ರು. ವಿ ಸೆಡ್ 6% ಕೊಡಬೇಕು, 9 ಕೊಟ್ಟಿದ್ದಾರೆ. therefore that itself should not be a ground ಅಂತ. While enhancing compensation and conventional rates, my lord may kindly look into this aspect.
ಇಲ್ಲ, ನಾವು ಯೂಶುವಲ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟು 6% ಎನ್ಹಾನ್ಸ್ಡ್ ಕಾಂಪನ್ಸೇಷನ್ ಮಾಡ್ತಾ ಇದೀವಿ ಎಲ್ಲರೂ. ಎಸ್, ಹೇಳಿ. So and so learned counsel appearing for the claimant contended that at the time of the accident, deceased was earning 20,000 per month he has produced Exhibit P29, payment details. Tribunal has considered that payment details for 4/5/2016 to 3/1/2017. Total amount of rupees 1,19,972.94 rupees. While assessing monthly income, tribunal has considered 15,000 per month is on lower side. Secondly, he has contended that in view of judgment of apex court in case of Magma, claimants are entitled 40,000 each, hence sought for enhancement of compensation. Per contra, Krishna Swamy Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 20,000 per month, working as a delivery executive, the payment slip produced by the claimants, it varies from each month. Therefore, tribunal has considered average income as 15,000 per month. Lastly, he has contended that considering that age and avocation of the deceased, overall compensation awarded by the tribunal just and reasonable. Interest awarded by the tribunal 9% is on higher side. Feroz, judgment and award and original records and original records. What is the name of the deceased? Jayananda died in road traffic accident occurred on 31/12/2016 due to rash and negligent driving of driver of car bearing registration number KA02 MF 7304. Even though claimant has claimed that he was earning 20,000 per month, but he has produced as a delivery boy in MS Instacart Service Private Limited. He has produced Exhibit P27 payment bill. Tribunal has considered payment received for the period of 4/5/2016 to 3/1/2017, totally for 7 months. Total amount of rupees 1,19,972 plus 94 paisa. The average, it comes 17,138 per month. Accordingly, monthly income of the deceased has to be considered as 17,138 per month. The tribunal has rightly added 40% of the income of the deceased for future prospects. Since he is a bachelor, 50% has been deducted for personal expenses. The multiplier applicable to that age group, yesterday 18. Accordingly, loss of dependency has been reassessed as follows.
17,138 plus 6,855 at the rate of 40%, 23,993 minus 11,996 at the rate of 50%, 11,997. 11,997 into 12 into 18, 25 lakhs 91,352.
In addition, 15 for loss of estate, 15 for funeral expenses in view of judgment of apex court in case of Magma. Who is first claimant? First mother, father and mother. Moornero? Aurik Barala. 1 and 2 is entitled 40,000 each for filial consortium. The enhanced compensation amount carries 6% interest. In view of order dated 5/12/2023, not entitled for the interest for enhanced compensation amount for a period of 112 days. 6% is. Yes.
Second time passed over matter, serial number 23, Rajaram S for appellant, Ravish Benny.
ಅದು ಡಿಸ್ಪ್ಲೇ ಹಾಕಿದೀರಾ?
ಹಾಕಿದೀವಿ.
None appears. Leaves this matter of 2 weeks.